Right, Lordship.
You are Mr.
T. Darren.
Mr. Land Council submits that the Land Council for the appellant, Mr. T. Darren, is out of station, and he has an instruction to mention on his behalf to list this matter after.
Lordship, 3 weeks.
Get it listed after
3 weeks, Lordship.
3 weeks. He has also obtained consent from the other side in view of the above, and is prayed for list this matter after 3 weeks. Okay.
Lordship, also item number 29, Lordship.
Yes. Here also.
Yes, Lordship.
Here also you have informed the other side.
Yes, Lordship.
Okay, similar.
Obliged.
Your Lordship, I beg to mention item number 30. I am appearing on behalf of Diki Pangi. I have taken consent from charter parties. Matter may be listed after 2 weeks.
You are Mr.
C. Tajo. On
C.
behalf of Diki Pangi.
Okay, you are C.
C. Tajo.
Tajo, appearing on behalf of Mr. Diki Bang, Land Council for the respondent, with the consent of the Land Council for the petitioner. Prays for listing this matter after
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks.
Obliged.
Okay.
Please, Lordship. Lordship, I beg to mention item number 10. On conducting counsel, Mr. K. Nolan is out of station. Matter may be fixed for
Which one?
item number 10, Lordship.
Item
10.
10.
Conducting counsel, Mr. K. Nolan is out of station, Lordship. Matter may be fixed for 20th of November.
Who is out
Lordship.
of station?
Conducting counsel, Mr. K. Nolan, Lordship.
You are Mr.
G. Thai, Lordship.
G. Land Council submits that the conducting counsel, Mr. Kemo Dolan, is out of station, and therefore pray for listing this matter after
Lordship, fixed for 28, Lordship.
28.
Of this one, yes.
Prays for listing this matter on 28 November.
Yes, Lordship. Lordship, there is an interim order.
List this matter on 28. The interim order passed earlier shall continue till then. Okay.
Deeply obliged.
Lordship, I beg to mention item 22. With the consent of the opposite party, this matter may be fixed on 27/11.
This is in order. Let us see the record. What is this is listed for order only? What is this matter about?
It is a matter about Lordship, we have challenged
No,
order passed by the CGM Pasigat Senior Division. They have allowed the replica filed by the respondent.
whether you have taken steps upon the respondent.
Yes,
Whether
here
they
is the
appeared.
respondent.
Yes.
You also
Yes, yes.
Okay, so you have no objection.
No.
Okay. On the prayer made by both the Land Council for the parties, list this matter
27.
on 27 November.
Yes,
Okay.
highly agree.
On the joint prayer. Joint prayer.
Your Honor, I beg to mention item number 27 for adjournment.
27.
Yes, Your Honor. The counsel is sick, Your Honor. Therefore, it may be listed after 3 weeks.
You for the petitioner.
Yes, Your Honor.
You are Mr.
Sorry, Your Honor. Oh, Mukbang Pertin, Your Honor.
M. Pertin. Submits that the conducting counsel is indisposed, and therefore pray for adjournment of the matter for a day. Please stop. Please pray for list this matter after
3 weeks, Your Honor.
3 weeks.
Much obliged.
May I Lordship? I beg to mention item number 26. I'm for a petitioner. Due to some personal difficulty, my senior counsel is unable to appear today.
You are for
I'm for a petitioner.
petitioner.
Yes, my lord.
Okay. Have you informed the other side?
Yes, my lord.
Okay.
So
You are
therefore,
Mr.
L. Rakap.
L.
L. Rakap. Rakap.
Land Council. submits that the conducting counsel, Mr. M. Kato, has some personal difficulties today, due to which he could not appear. Hence, pray for adjournment of the matter
So-
for the day. So he has also obtained consent from the other side.
So therefore, my lord, letter will list for 3 weeks after.
Please pray for Kama. List this matter after 3 weeks.
Of place.
May I please, Lordship? Lordship, bail application under section 483 of BNSS, in connection with Naharagun case number 119 of 2024, FIR on page number 20, and the accused person was arrested on 13/9/2024, Lordship. Today is 41 days.
FIR
FIR in page number 20.
21B.
Yes, Lordship, 21B. 12.6 grams was recovered
From him.
from him. Actually, from his vehicle.
So he was arrested on
Arrested on 39/2024, but
39.
forwarded on, yes, Lordship, forwarded on 2 October 2024. Before and if it's special just.
Have you moved bail application before the trial court?
No, Lordship.
Why you have come here straight away directly here? Why you have?
As because the special is having power before this honorable court for granting bail to the accused person.
Who has power?
Before this honorable court, Lordship.
But then trial court
No,
knows
Lordship.
best
Not
what to do
no,
with the
not
accused.
not before this trial court. Lordship.
Why?
Let it come to this high court, Lordship.
You used to exhaust first before the trial court.
Yes. Once the bail is rejected here, then it will be difficult for him. The trial court will.
It will be
Hardly
difficult for
allowed.
him to move before the trial court thereafter. What is the ground for your bail prayer? On what ground?
Today is 41 days, Lordship, and call for the CD.
So what? But it is 21B
Yes, Lordship.
under 27 and 29 NDPS.
Yes, Lordship.
Then
90 days
No, today is most one for Lordship. Call for the CD.
why?
ground.
Why the CD should be called for?
The fact CD will reflect the fact
What
whether it
fact?
is
What
21B or not.
What fact? You are innocent or what?
Yes, I am innocent, Lordship.
Where have you stated?
Once Charlie Wangfu was the
You
main
just
accused.
tell me that it was recovered from your possession of the petition.
I have mentioned in my petition, Lordship, the actual fact of the case, Lordship, in para number 7, Lordship, page number 6. The petition of actual fact was that one Charlie Wangpo, Mrs. Charlie Wangpo, along with Nabam Juni, resided at Dokom Colony, F sector, Naharlagun. The police search conducted upon both of them, and 2 vials of suspected heroin was waiting for 0.5 grams was recovered from the possession of the Charlie Wangpo. On 39/2024, the accused was present before this honorable, before the NDPS EPR, before the special just NDPS EPR, Lordship, for appearing his case in connection with Bandardia case number 01 of 2029, NDPS case number 15 of 2020. One unknown lady called the accused person Binod Saman 2 p.m. to meet her at Naharlagun to discuss about business related issues. But due to his tiredness, the accused person has appeared before the special just NDPS EPR on in connection with NDPS case number 15 2024 or 2020, arising out of Bandota case number 1 2020. He was unable to talk with the unknown lady properly. After returning from court, he was in Harmoti, Assam, the unknown lady again called him and requested him to meet at Bandardeva, Harmoti, and accordingly he went to meet the unknown lady, and then come to know that the unknown lady was Miss Sarli Wangshu. And when he read the inside his car, then immediately another 2 person inside forcefully entered into his car, and lastly this person come to know that the persons were police. As because the accused, namely Charlie Wangshu, already interrogated by the police, and on the statement or on the pre-plan with the police, they have arrested the accused person, Lordship.
My lord will find in the remand order, your lordship. In my humble submission, your lordship, what I would submitting is, your lordship, let him approach the trial court first, your lordship, since it is the discretion of this honorable court regarding granting of bail as well. Now, since he has not approached the trial court, even the trial court has reflected here in the remand order that since he has not filed the bail application, the court has sent him for judicial remand. Now, the trial court will be in the better position. Your lordship may kindly come to page 24, Annexure 5. The lordship will find the accused so-and-so has produced before the court today by team of so-and-so after expiry of 5 days, police custody granted in connection with aforementioned PS case. By this application that the so-and-so, Sri SI so-and-so Nagalagan PS has submitted that the custody interrogation of the accused has been done in the present case. However, he has prayed that the accused may not be released on bail as he is a habitual interstate drugs peddler, which require thorough investigation. Therefore, IO has prayed to send the accused to judicial custody as Julie jail. I have perused the application along with medical fitness certificate, wherein examining doctor has opined that accused person is fit to be kept in custody. As hearing so-and-so is present and raised no objection as well as legal formality have been done. As prayed by IO and in absence of any bail application, let the accused person, namely so-and-so, sent to the judicial custody for 14 days and he shall be produced before the court after expiry of the judicial remand if required. Your lordship, in every stage, if suppose no doubt, your lordship, there is no any bar as such, and it's pending before the Supreme Court as well, whether a person can be, an accused can be directly approach the High Court order without exhausting the remedy. But your lordship, here, your lordship, he has not, it's a regular bail, it's not even an anticipatory bail, your lordship. He has not even approached the trial court once. Let him approach the trial court once, and if it is rejected, he can come before this honorable court. Let him exhaust his remedy, at least from the...
Yes, you have not moved bail application to the trial court. Trial court has observed that in absence of any bail application.
Yes, your lordship. He has never approached. He directly approached this honorable High Court.
Why you have the always exhaust
Yes, your lord.
the provision provided under the law to the lowest court. But anyway, since he has already filed, he can call for also. But it is disadvantage only.
Yes, he is despite the advantage, your lord. That may be reflected in the order that without approaching the trial court, so that in later stage he may not go for withdrawal.
It is the advocate who should suggest the client, and it's choice of the advocate. Why you should approach High Court first? You knowing that it has to be first before the trial court.
Yes.
What is the interest?
Is there any bar? I have no knowledge, lordship, but I have filed before this honorable court so as that I may able to get the bail order also. There is no any specific rule also that trial court first of all it is the
First
duty
of all, you have to approach before the trial court. After exhausting only you can come. There is no bar as such, but then it's always better for you. But Mr.
G. Fupon.
Counsel, for the namesake, why should you file? Knowing this fact and knowing that it has to be filed before the trial court. Non-counsel for petition. This is an application filed under section 483. of the BNS 2023, praying for granting of regular bail to the accused. The accused himself is a petitioner.
No, Lordship, his wife, Munu Sharma. Accused is Binod Sharma.
Why you have then stated the accused petitioner? Read the first. It's accused petitioner. That means the petitioner is the accused, isn't it?
No, Lordship.
Read it. Post title, first paragraph, praying for granting regular bail to the accused petitioner. Kindly read it.
Yes, Your Lordship.
Read it loudly.
Yes, Lordship.
Read it.
An application under section 483 of the BNSS 2020 praying for granting regular bail to the accused petitioner who was in jail
And then-
since 7.
The accused is the petitioner. The petitioner is the accused.
No, Lordship. Typographically wrong it may be.
See how
But
long
in the petition I have
how
mentioned.
long will we allow you to keep on correcting?
Then I may be allowed to withdraw the petition, Lordship.
It's better. You withdraw, file before the trial court, then come.
Let's see.
Then there will be
Let's see what will be happen.
some reason to entertain the bail. Because Mr. Direct Counsel for the petitioner wants to withdraw this bail application.
But it is not a ground for accused petitioner. Yes, maybe typographical error. But it is not a ground that my petition should be withdrawn under instruction by this honorable court, Lordship.
Okay.
Because
No, what do you want now? You
I'll
can
withdraw, Lordship, withdraw.
you will withdraw. Okay, want to withdraw this bail application with liberty to file a fresh. So the prayer is allowed. This bail application is dismissed on being withdrawn with liberty as prayed for. Okay. You first approach the trial court. It's
Let's
okay.
see. Let's see. Apply such.
May I please, Lordship?
Yes.
Lordship, this is an application under section 528 of BNSS for quashing of FIR charge sheet in connection with GR case number 644/23. Lordship, the present case has been filed jointly by the accused person and the victim or the complainant of this case. Lordship, the allegation against the accused person is
The
section-
326.
Yes, Lordship. That is voluntarily causing grievous hurt,
Grievous or-
Lordship. Lordship, since the accused person and the complainant victim, they are known to each other and they have already executed and mutual settlement, a deed of settlement on dated 18 day of July 2024 for quashing of this present case, and today they have jointly filed this petition before the
So what is the status of case in the before the trial court?
page number 40, annexure 4. Lordship, so far only the charge has been framed against the accused person under section 326.
326.
Yes. None of the prosecution witness statement has been recorded so far. So, Lordship, since the matter has been already settled between the parties and as per the judgment of
What is the minimum punishment?
minimum punishment is
7.
7 years. Lordship, in the case of Lordship is well aware that Narendra Singh versus State of Punjab and others, the Honorable Supreme Court has said that once the settlement has been done between the parties, for the interest of justice, quashing can be done. Lordship, even in 307 cases.
Yes.
Many others, this is not a universal law that will applicable in every every litigations. Victim circumstances has to be seen. Here, your lordship may find photograph also. It is there is so much serious grievous injury.
Yes,
It's not like by yes.
charge sheet filed against accused under
25.
325.
Yes,
So the charge framed under 2326.
yes,
The Land Court found prima facie against the accused under
yes,
for commission of offense under section 326 only.
yes, lordship.
Hmm.
Initially, the charge sheet was filed under 325, which is compoundable in nature.
So then in that case, we may have to see the
Yes,
record.
third court.
Yes.
Or Mr. T. Tabak, Land Counsel for the petitioner. This is an application filed under section 528 of BNS Act 2023 for quashing and to set aside the proceeding of GR case number 644/23 of arising out of the PS case number 183/23 under section 326 of IPC pending before the court of the Chief Judicial Magistrate, Capital Complex, UPR staff. No, it will begin. This is a joint petition, huh? Joint petition filed by the accused petitioner number 1 and the informant petitioner number 2 on a section, huh? Okay. So hold for the scanned copy of the trial court record. So, issue notice. Start. Since Mr. G. Tado, Lanet Additional PP, has accepted notice on behalf of the responding state, no formal notice required to be sent to the said respondent staff.
Lordship, I have an interim small prayer for staying of the proceeding.
List this matter. Well, when this can be listed?
20 days after. 3 weeks.
After 3 weeks.
Okay, list this matter after 3 weeks. So this is a serious case. Interim may not be possible at the moment. Say, how do we stay? There is a prima facie case against you for commission of offense under section 326. Let us see the record first.
Till
Charge already framed.
yes, till the arrival of record. So at least if I is there for the interest of
No, it will be difficult. The serious case, you yourself has annexed a medical document, photographs. It's serious. Medical document also clearly reveal that grievous, the injuries are grievous. And the photograph of the next.
Lordship, yes, this is a record. This is a part of the charge sheet.
Yes,
Lordship.
yes.
That's why I have an
That is
Lordship, but then also, Lordship, the treatment has been carried out by the early accused person and they have already settled the matter outside the court. Since the nature of the case was non-compoundable.
Let us see since charge has already framed.
Yes, charge has been framed.
And then the first to be called would be the informant, the injured person. Now, once we go to court, once he deposed the injured person, since he is with you, he cooperate you that there is nothing, then the court will be able to come into the conclusion that it will be a futile effort. Then the rest of the trial will be.
Lordship, paragraph 29 of Narendra Singh case says that if the matter has been,
He is on bail only.
yes, he is on bail. He's on.
So, list this matter on after 3 weeks. The on the interim prayer shall be considered on the next date. Okay.
Next.
Hey, please. Madam, this is an application under. Yes, this is an application for quashing under 482 and 528 of BNSS. For quashing of the charge sheet number 171 of 2017 under section 279 and 338 of IPC. 279 and 338 IPC. Charge sheet has been filed.
Gross and negligent driving. Gross and negligent.
That's a negligence.
Okay.
And the FIR is,
279.
yes,
338. Okay.
FIR is
So
at
this is
page
joint
50.
petition
Yes, joint petition. Here the petition.
by the
Petitioner number 1 is the informant here. And
petitioner number 1 is informant.
yeah, one is
Who is the
the
accused?
3 and 4 is the accused. They are the accused.
And who is the
2 is the victim. Actually, what happened is that, my lord, here on the 22nd of February 2017, is the bike of the petitioner number 2 and 3. 3 was the rider of the bike and 2 was the petitioner number 2 was the pillion rider.
The 3 was
The rider of the bike.
okay.
And 2 was the pillion rider. Collided with the
2. Huh?
2 was
One.
the pillion rider.
2.
Yes, victim was the pillion rider. 3 was riding the bike and 2 was the pillion rider. Collided with the vehicle of the petitioner number 4. And they've sustained injuries and they were shifted to the medical Arkham Mission Hospital. And during the investigation, while undergoing the treatment, the petitioner number 4, she is accused. She has approached them and paid their financial.
The petitioner number 4 is accused.
Accused, yes.
4 is accused.
4 and 3. Since the 3 was the rider of the bike, he was also charged sheeted.
4 is also accused.
Yes,
Who is the informant?
1. 1 is the informant, 2 is the victim.
Whether 1 is the victim.
No. Petitioner.
Okay, 1 laws
the
FIR against
FIR against the
3 and 4.
offending vehicle. Against the offending vehicle. My lord, FIR is at
Offending
page
vehicle, which
50.
one? Of 3 or 4?
Vehicle of 4.
4.
Yes.
No, he laws FIR on whose behalf?
On behalf of 2 and 3.
Okay, so according to the informant,
Yes.
there was a mistake on the part of the respondent number 4.
FIR is at page 15. My lord. Type copy is at page 16.
Page
15.
15.
Type copy is page 16. This was the FIR. Page 16 is the type copy. This is the informant. This lodged the FIR. The undersigned would like to inform you that my brother Techi Butum, he is the petitioner number 2.
Okay.
Along with his friend. His friend is petitioner number 3. Came from Naharlagan to Itanagar on his way to his residence. He and his friend heated Duster Renault. This Duster is the vehicle of the petitioner number 4.
Okay.
Around so and so, bearing registration number and
Okay.
is
Hit and run.
yeah, hit and run. At
Run
the same
away.
time, they were heated, are medically admitted in very serious condition. Moreover, according to the eyewitness, one who heated my brother's bike was very drunk. Therefore, I kindly request you to STIP department to take the actions.
Okay.
This was the FIR.
So, okay. Then charge sheet filed.
Yes, charge sheet at page
What is the stage of the
19.
trial?
It's for appearance. Appearance.
Only for appearance.
Appearance, yes.
Charge not yet framed.
Not yet framed. Actually, what happened is that this case was of 2017. And during investigation, the parties they have mutually resolved, though no any agreement was executed at that time. Then after after lapse of 6 years, suddenly in the month of July this year, the accused number 4, the petitioner number 4, has received the summon PL4 from the Honorable Court. Page 37 is the previous, the last order. 37 is the order of the trial court. Here, yes, petitioner on behalf of petitioner number 4, on the 22nd of August, yes, the council has appealed. And hereafter, they have filed the dispense application. This is the petitioner number 4 could not appear on the said date.
Yes.
And page 38.
It seems they have settled the matters among themselves.
So what do we do? What is your submission?
It can be disposed of. Yes, or pass any necessary order.
Record need to be called or it can be disposed of?
Pass any appropriate order. That may be referred.
No, yeah.
By the whole charge sheet I have annexed in the annexure Cs.
That's because why I am submitting that point, because in entire agreement, there is no monetary consideration was mentioned. Otherwise, it will be vitiate the settlement agreement.
Otherwise,
It will be vitiate the settlement, authenticity of settlement agreement. Sometimes it's what happened. One person commit mistake and thereafter they offer money just to settle the things.
so here no money was offered.
No money was.
No.
No compensation.
No, since it was in 2017 itself when the incident happened, the injured was treated by the owner of the offending vehicle.
What is the punishment under the
6 months. Since 279 is non-compoundable, punishment is 6 months or 1,000 fine. I have a judgment of similar
what it says?
sections wherein the
Yeah,
Honorable
what it says?
the Honorable High Court, in the interest of justice, since the parties have settled their dispute, there is no likelihood of any acrimony or burden on the state exchequer. So the case was quashed and set aside. Relying on the
Yes, yes.
judgment of Gyan Singh and Lakshmi Narayan.
Okay. So the second party paid all the medical bills, etc., expenses.
Yes.
Means it was settled properly. No points. Keeping it pending. Not necessary even to call the record. I think there, you have annexed all the
Charge sheet.
entire charge sheet
Yes, ma'am.
and there is nothing appears. Because they thought that it was already settled. And suddenly after 6 years it has come. So I'll submit the, yeah, I'll record the submission. Okay. And then the last order in the chamber, okay. Just heard Mr.
S. Sumit Chetri, my lord.
Sumit Chetri, Islamic counsel for the petitioner. I have also heard Mr. G. Dadav, with additional PP. Staff, huh? For the state, huh? Of the come. This is a joint petition filed under section 482 of the Criminal Procedure Code 1973 within bracket the corresponding section is 528 of Bharatiya Nagarik Suraksha Sanhita 2023 bracket close, praying for passing of the charge sheet. No, where is, have you mentioned passing of GR number
Below the amount.
GR number 111 2017 arising out of where is the PS case? Itanagar PS case number 38 2017 under section 279/338 IPC. Then pending before the Court of Judicial Magistrate First Class, UPR.
It is Chief Judicial Magistrate. Chief Judicial,
It's a Judicial Magistrate First Class only.
but final form it is written CJM. Letter it may be endorsed.
No, page 37, the last, it's proceeding as.
Letter it may be endorsed to
Proceeding is under
Page 38, 37, 38, yes, the last order.
Judicial Magistrate.
Yes, first order, first. Right, when proceeding has been initiated.
Okay. The petitioner number 1, Sri Techi Nekam, is the informant. Semicolon. Petitioner number, the petitioner number 2, Techi Butum, Sri Techi Butum, is the victim, who was the victim, stroke alien rider, semicolon. The petitioner number 3, Sri Vikram Gingba, GINGBA, was the rider of the motorcycle, and the petitioner number 3, Srimati Toko Jasmine, is the accused in GR case number 111/2017 arising out of Itanagar PS case number 38/2017. Start. Then the rest will be I'll dictate.
My lord, if I may, here's the petitioner number 3, the Vikram Gingba, who was the rider of the bike. He has also been made as a case number 1 in the charge sheet. And petition number 4 is the accused number 2. 2 accused here
Okay,
for rash and negligent right.
then against 3, huh? The petitioner number 3 is Vikram Jimbai.
I mentioned in paragraph 2.
Okay. Right, who was the rider of the motorcycle is
Yes.
the accused. He is
Number
accused number, he is made as accused number 1.
Accused number
Okay, accused number 1. And then the next would be
accused number 2.
the Jasmine. The prisoner number 4, Sri Jasmine, is the accused number 2. Jasmine, the driver of the offending vehicle is accused number 2, right? Okay. Then rest.
Yes, madam.
It is in the stage of, you say that it is in the stage of
Appearance.
appearance.
Page 38.
411.
This on 4th of 11, the board was on page.
Here,
Para 6 and 7.
relevant is para 6 and 7.
Yes.
Yes.
Quickly apply. No.
This item is portion 3. Okay. Take it, huh? Yes.
Very good morning, Your Lordship. Your Lordship, I understand that the time of this court is way too limited, but my fact is so exhaustive. I'll try to make it nutshell as much as I can. I covenant that. Your Lordship, this is an writ petition filed under Article 226 of the Indian Constitution, praying before this court to issue a writ of mandamus against the respondents to compel them to dispense the statutory obligation that has been cast upon them, which they have been evading from almost years back now. The fact of the case goes as like this, Your Honor, Your Lordship. The father of the petitioner, late Mr. Ganesh Baidia, has joined the state service in the power department way back on 17 February 1997, Your Lordship. On 17 February 1997, the father of the deceased father of the petitioner he joined at that point of time in the state service as a West Khalasi. So until 7 April 2021, he was working sincerely in the service of the state for almost 24 years, 1 month and 22 days approximately. On 7th April 2021, Your Lordship, at around 7 a.m., he climbed in a transformer of high electricity volt transformer to dispense his duty, which he had been doing for a very long time, and during which he got electrocuted by 11 kV volt. And so, in a nutshell, the father of the petitioner died while working on duty, Lordship.
At the time of this date, whether he was a regular employee?
Lordship, yes, there is a crux now. His service was put in a motion to regularize, but he was not. So, but after few days after he died, his paper came that his confirmation letter came that he was regularized. So, and Your Lordship, we do not have the letter as of now, but from where I'm signifying that is that the family is receiving pension, Your Lordship. There is a letter I will.
Where is the letter regularization of the?
I will leave, Your Lordship. Just need 5 seconds, Your Lordship. Your Lordship, may you please refer to page number 33, Annex 01. Page number 33, Annex 01, Your Lordship. Your Lordship, this is not directly a confirmation letter, But if we see the last, second last paragraph, Your Lordship, which start from further, second last paragraph of this annexure, Your Lordship, after after that fateful day when he died, this is a letter formulated by the by the executive engineer to the superintending engineer, saying that it is to apprise your good office that till today the service of late Ganesh Baidia has not been confirmed for regularization, and in this regard, service book part 1 and part 2 of late Ganesh Baidia will be forwarded to your good office for regular confirmation and for smooth processing of pension case separately. After this, Your Lordship, from where I'm signifying that the service was regularized, the widow started receiving pension, Your Lordship. There is one more annexure. I would beg Your Lordship to please kindly refer to that annexure as well. Your Lordship, may you please refer to page number 39, annexure 6. Page number 39, annexure 6, Your Lordship.
What is that?
Your Lordship, this is a letter, official document formulated by the Office of the Director of Audit and Pension, Government of Arunachal Pradesh, Naharlagan. In point 1 of this letter, it says, total period of qualifying service which has been accepted for pension, gratuity with reasons for disallowance, if any. Your Lordship, 24 years, 1 month, 22 days. So, Your Lordship, I believe there is no problem when it comes to the issue of regularization, Your Lordship.
Since he was not regularized, what was his post name?
West Khalisi, Your Lordship, WC. He used to carry out all the critical works which any ordinary person would not dare to do, Your Lordship. Lineman.
So you filed an application?
Yes, Lordship. What happened after that? We have moved, Your Lordship, page 40, annexure 7 series. Page 40. Mr. Gokul Baidia, who is the petitioner, he humbly made a representation to Mr. Kripak Dini, executive engineer, and to the superintending engineer in the Pasigat Circle, praying that on a compassionate ground, if his matter can be entertained and his matter can be put into motion so that he may get chance to at least run the race of whether being qualified or disqualified by the selection committee for compassionate appointment. And it's a 7 series, Your Lordship. Now, what is the strange here, Lordship? After filing this this application by the petitioner waited until this year, Lordship, for 5 months. For next 5 months after filing this petition, we have waited with a faith and hope that the respondent state will dispense its obligation, even if they will not grant directly compassionate appointment, but at least some sort of reply, Your Lordship, be it negative or affirmative, saying that you are okay, we'll do it or not do it. But there has been complete silence on the part of the respondent, executive engineer, Mr. Your Lordship. So after they agreed by such nonfeasance and complete silence, what the petitioner did again, he again say in reference to that first letter, Your Lordship, he sent a second letter again. If I may lead Your Lordship to page number 42, annexure 8 series.
Okay, whether the respondent authority has passed any order thereafter? No.
No, Your Lordship. No, Lordship. So this is why
any scheme for the appointment?
Yes, Lordship. There is a superseded ripple scheme as well as the operative scheme. I will lead Your Lordship to the operative scheme. Your Lordship, in page, I believe I need not to take the entire pages. I will just cite out the scheme, Your Lordship. There is a master circular on a scheme of compassionate appointment, Your Lordship. Now, this scheme of compassionate appointment is actually formulated by the central government, but the state of AP has also adopted it by official gazetted notification, saying that this scheme of compassionate appointment, which has been accepted and practiced by the central, will also be adopted by the state ditto as it is. So, Your Lordship, after filing first application, we waited for 5 months.
Whether in the department,
sorry, Lordship.
there may be some other applicant also in the same department.
The
department used to maintain seniority of the applicant.
Your Lordship, now I need
application.
Yes, Lordship. Now, there is the crux, Lordship, why we are here before you to pray for this for the prayer, Lordship. Now, there has been complete non-feasance, Your Lordship. At the least, what we expect and what the duty which scheme of compassionate appointment cast upon the respondent is this: the executive engineer have no authority whatsoever to reject or to accept, saying that he has been granted appointment. All that the executive engineer has to do as per the strict mandate of this scheme is that the moment executive engineer receives any application for compassionate appointment, he have to scrutinize all the documents, whether it's correct, wrong. He have to do all the clerical work and then forward it to superintending engineer, which will in turn send it to the selection committee, which then your lordship whole procedure of talking on merits will start, your lordship. But we forgot about, we left behind the hope of getting appointment, lordship. Now our problem is that our matter is not even being moved, your lordship. The executive engineer, Mr.
Where it is pending?
in the office of executive engineer, Mr.
Executive
Kirpak Dini.
engineer has not
Yeah.
yet forwarded.
So your lordship, sorry.
Executive engineer has not yet forwarded your application.
No, lordship, when we
Where
go
it
to
is-
meet, he
where it
don't
is
even
supposed
meet.
to be forwarded. Where-
Sorry, your lordship.
Where it is supposed to be forwarded.
Your lordship, we believe humbly, since he's not the competent authority, so the proper channel would be to forward it to the superintending engineer who resides in Pasigat, the circle, because that office is division subordinate office, your lordship. So, okay.
Yes.
Your lordship, if you may permit,
This is a notice, maybe go, my lord.
Mr. You are Mr.
Marge Lombi, your lordship.
Marge,
Lombi. MARGELOMBI, Marge Lombi.
Land Council for the petitioner. The case of the petitioner is that his father, late Ganesh Vaidya, who was working as WC Khalasi, working under the department of
Our department, your lordship.
under power department, died in harness. Leaving behind him the petitioner and how many family members?
Total, there are lots many, but technically who are dependent, there are only total four, your lordship. Five, sorry.
Petitioner and
Five.
four other.
Petitioner and four other, yes.
Dependent members. It is submitted that the father of the petitioner, late Ganesh Vaidya, was the only great honor of the family. And after his death, the family was left into penury. So finding no other alternative, the petitioner made an application before the respondent authority. He submitted an application before the respondent authority through executive engineer, the Kabali Electrical Division, Power Department, on when 18/12/23. 6/5.
18 December 2023, your lordship.
6/5/2024. However, the said application has not yet been forwarded by the executive engineer is respondent.
Number 3, your lordship.
Okay. In the earlier also, the executive engineer respondent number 3. Stop. 3. Okay. Not yet forwarded by the respondent number 3 to the superintendent
Engineer.
superintending engineer, electrical circle 2, power department at Pasigat for consideration of his compassionate appointment. Your prayer is only to direct the
Your Lordship, yes.
respondent to forward your application only.
Yeah, Lordship. And if it is rejected at last, also we will not contest. We just want to run in the race, Your Lordship, to get that opportunity. Yes, Your Lordship, you are correct. A mandamus.
Then the writ petition can also be disposed of with the direction to dispose, forward your application.
Yeah, Your Lordship. If that can be done also, we at the least we are happy.
I think
If the state do
that
not
can also be
oppose.
done.
But Your Lordship,
I'm not sure about
His
this
only,
prayer, my
I
lord.
think limited prayer is to forward.
yes, Your Lordship. Lordship, there is
The
one thing, if
application
you may allow, I need to
Notice, my
say.
lord, for that also notice remark, because my lord, if my lord kindly turn to page
Okay,
number,
okay. Then, then issue notice
Your Lord.
returnable by 4 weeks. Since Mr. You are appearing on behalf of,
for 2 and 3, my lord, extending the power department.
okay, since Ms. Pango appear and accepted notice on behalf of the respondent number 1 and Mr. Desin Permit for respondent number 2 and 3, comma, no formal notice required to be sent to the said respondent. So, however, the petitioner shall furnish requisite extra copy to the land council for the respondents during the course of the day. Staff. Please this matter after 4 weeks. Okay.
God bless you. Much obliged, Your Lordship. Much obliged.
May, my lord?
Yeah.
My lord, we need some more time to file our reply, my lord.
You are Mr.
T. Kamchi.
Mr.
Dear.
You are for the petitioner.
Yes, ma'am.
Okay, Mr. You are Mr.
Dear.
D. Ado,
Yes.
land council for the petitioner. So, I had Mr. D. Ado, land council for the petitioner. Start. Mr. T. Kamsi appearing on behalf of the land council, sorry, the respondent. Praise for father, how much time?
2 weeks,
Father, 2 weeks time.
3 weeks, lordship.
Father, 3 weeks time to file.
Reply.
Reply.
Affidavit in opposition.
Affidavit in opposition. The prayer is allowed. Please this matter after 3 weeks. Okay.
Much over.
Much over.
Yes,
Lordship, this is a bail hearing, Lordship.
yes.
First of all, Lordship, this accused person has been arrested on 3rd of October 2024. This, as I have earlier also submitted, this matter is of civil nature, case is of civil nature, allegation is of civil nature. This is a complete breach of contract. I have even
Who appears for the respondent?
enclosed the memorandum on this agreement.
Just a minute. Who appeared for the respondent? Mr. Tado? No, it's Genie, T. Genie.
I would like to take your lordship to page number 15, annexure 1. This is the FIR. In this FIR, it is clearly written that this Dheeraj Paul, the accused person, he was representing the Rodas State Private Limited.
No any, just a minute. Case diary was not called for here in this case.
I think case diary has already.
This is,
Case diary has already come.
it has come.
Yes, already come. I have just talked to my brother. Item number 11.
Your Lordship, here in this case, in order, case diary has not been called for, but we
Case
have,
diary has
we have
been called.
received case diary.
Should have been called for.
Yes,
Yeah,
it's a maybe inadvertent mistake from this by the time when we are making submission, Your Lordship. Otherwise, notice has been issued which is returnable today itself, and we have received the case diary, Your Lordship.
You have received?
Yes, with us.
Okay.
They can-
So what?
That can be hard.
When he was arrested?
On 3rd of October.
October.
Yes. Today it is 1 month, 10 days.
Allegation is 4/20.
Yes. I don't think there is any further custodial integration in this matter because he was taken on police remand and it was over. And then he was put on judicial remand. It is going on. But the matter is only a case of civil nature. Out
Civil
of
nature.
civil
No, no, no,
contract.
no.
This is the issue.
Your
And
Lordship,
the amount is also
Let us see
admitted.
the allegation. Let us see the allegation against the accused.
Your Lordship, the FIR itself clearly disclosed the commission of the offense. Why I am saying so, Your Lordship, for installation of tower, Your Lordship, for installation of mobile tower,
Hmm.
how a person can assure the other person to give or offer or grant him the tender for installation of tower without floating any tender process, and first of all, and secondly, Your Lordship, if that person has the authority, then he ought to have asked for bank guarantee, EMD. These are the tender process, Your Lord. These are the basic things, Your Lordship. Here he has taken the money directly into his own account. And he is claiming that he is the director.
Not director, executive.
Executive.
Allegation is that I was director, but I am the chief executive officer.
But why
He-
he has given?
Your Lordship, he is saying he is the chief executive officer. Your Lordship, he has been allured. That's why this is the dishonest intention, which was from the inception. And Your Lordship, in recently also, Your Lordship, the Supreme Court went to that extent that it is not only the intention, it is the conduct also. There was an instance, Your Lordship, if suppose a person has been given his truck for a lease, and initially he paid an amount, and later on that person discontinued to pay the lease amount, that will clearly attract the dishonest intention for which the investigation is required to be done. Here in the case, Your Lordship, that person, they come to know in the later stage, Your Lordship, that the tower has been installed by the other company. Not only in this case, there are many more cases are pending in this, Your Lordship, after this one AB will also come. And you here in this case, Your Lordship, he has been directed to produce certain document in connection to absolve his, Your Lordship, involvement. But as on that, he is failed to submit such document, Your Lordship. Your Lordship, it is there in the status report, Your Lordship. May I read, Your Lordship?
Just a minute. Let us see the FIR, correct?
Yes, Your Lordship.
This is the director.
There is a clear-cut agreement. He was supposed to work as a subcontractor. The complainant is the subcontractor in this case. Kindly refer to this agreement. Lordship, kindly see the agreement is
The MOU
page number
also
21.
executed between the parties.
Agreement was executed as per this is a clear-cut case of the civil contract. There are so many Supreme Court decisions, so I'm ready to cite all those cases. Under these circumstances, what can be the decision? No prima facie case under the criminal ingredients is not made out under 420 IPC. Even then, in the name of investigation, nothing to be investigated. We have already refunded the money up to 48 lakhs out of 92 lakhs. And we're saying that 9 lakhs is yet to be refunded, but the sum of the amount complainant is disputing. But even then, till now, I am ready to repay the money as per the payment record, whatever it is.
Except for the fact that he is not the director.
Yes, I am not director, I am the executive.
But
And Your Lordship, the
appears that it was-
second aspect
it
would be,
was-
Your Lordship, second aspect would be whether they have the authority or whether they have been awarded with that work
No, no,
to further offer it to any other contractor. Now he is saying that, yes, I am the director or whatsoever, Your Lordship, if, chief managing director whatsoever, hypothetically, assuming, Your Lordship. But whether they have the tender work within them.
No, you just see.
This is not a
Once.
consent. This is
So,
an agreement, this is
the
contract. of-
FIR
as a
says- the FIR
subcontractor.
says-
Here's the agreement.
The FIR says the accused approach for financial assistance to carry out the installation of airtel tower.
Yes, Your Lordship.
They agreed to provide finance for the said work. And it was not refunded only. It appears
Your Lordship, however, the above named person has failed to fulfill his commitment. Now, this is the term commitment and has not returned the fund provided amount to him. He is evading communication and has shown no intention to repay the amount, indicating a clear intent to defraud.
To repay.
Yes, Your Lordship. Now, Your Lordship, so far as the FIR is concerned, Your Lordship, it prima facie disclosed, Your Lordship, the offense of 420, Your Lordship.
No, except for that he introduced himself as a director. I think it was a financial assistant extended to the accused, and then he did not refund on time.
Yes, Your Lordship. He introduced himself as a director in first paragraph, right, Your Lordship. Now, in the last paragraph, Your Lordship will find it has also come to the light that he is not the director.
He is not a director, only that, except for that, I think the others, this is only the transaction, money transaction between the petitioner and this accused and I think the informant. So only the question is that he did not repay, and he did not respond.
Then it is, this is his conduct, Your Lordship.
But you see, what was his intention also to extend 15
Yes,
days and 42 days?
Your Lordship, that is what I'm submitting, Your Lordship. The intention, Your Lordship, the intention, mens rea, so far as in this kind of nature of case, Your Lordship, it is very difficult because it's a, Your Lordship, the mens rea intention is in mind, which can be called out during the trial, no doubt. But so far as the present case is concerned, to collect the material, the proper investigation is required to unearth the truth. And moreover, Your Lordship, this is not only the case where this person is involved. There are other cases are also where the person has done the same offense, committed the same offense, Your Lordship, with different person.
No, this is not a criminal breach of trust. It's 420
420, yes, Your Lordship.
IPC.
Yes. Your Lordship, this is the status report, Your Lordship.
What it says, whether the custodial interrogation.
Yes, Your Lordship, it's required because he failed to even produce the document in his support, Your Lordship. Whether he has the authority to give such work to any other person or for installation of such tower or not, that is not there, Your Lordship. Your Lordship will find in the status report. Your Lordship may kindly peruse the status report.
Now, we do not know exactly for what purpose.
It's reflected in the status report, Your Lordship. If Your Lordship satisfied, then reject it. If Your Lordship is not satisfied with the status report, yes, I will leave it to Your Lordship. That much I can submit.
So relevant portion.
It's in the last paragraph, Your Lordship. Yes, last during yes, that part, Your Lordship.
Just a minute.
Full submission. It is there here.
He was accused in multiple cases. But that is not connected here. Earlier, your bail was rejected.
Yes, before the Janet.
JMFC. On what ground?
That was that investigation is going on.
Okay.
May make the submission laws. It's in full length. Just make a matter understand.
Yes, what is your submission?
Yes, my submission is one is procedural aspect. Procedural aspect is what is the requirement of further custodial interrogation of the accused person. That is the procedural aspect. Kindly see on merit. Kindly see the FIR. FIR says clearly says this accused person, Mr. Dheeraj Pal, who is the director? It is yes, right, director. It is not director. It is chief executive officer of MS Rodas State Private Limited. This person is representing this Rodas State Private Limited in all the business transactions of the firm. So in so many cases, he has been entangled as an accused person because money was deposited, but there was a breach of contract, money somewhere not paid, somewhere partially paid, somewhere there are so many complaints. That is the issue here. So what happened in this present context, in this present case? This complaint is Mr. Jumda Padu and one another. He has said in this case there was a before this filing of FIR there was an agreement. Agreement was on page number 21. Kindly see page number 21, annexure number 6.
Agreement.
Page number 21 of the bail application and annexure number 6. Page number 21.
Yes.
Annexure 6. This is a memorandum of understanding. This complainant, Tunganiri and Jumda Padu, they are the first party and second party is Dheeraj Pal. The agreement was that some subcontract work was to be executed. On the basis of the such terms and conditions, the work was to be executed for which a sum of rupees 92 lakhs was deposited in the account of the this complainant.
Complainant?
Not the complainant, this accused person. Kindly see page number 23 of the agreement, terms and conditions. Responsibilities of the party specified body, but not limited to this. The work was subcontract and carrying out the work. Last paragraph. The first party shall be responsible. And who is the first party here? First party is this complainant. Responsible for facilitating provision of enhanced financial participation in the capacity of partner. It was to finance this work activities as a partner of this contract above and the side and the participation as to said subcontract in carrying out the work. The partition provides a detail, providing technical supervision and promote services of such and such. That is in short, it was the first party, the complainant was to enter as a subcontractor in the matter. So when the works failed during this existence of this agreement, the work was to be executed in terms of the terms and conditions of the agreement. And then kindly say, when the works failed, the money was to be refunded, definitely. Accordingly, in terms of the agreement, when the works failed, the 87 plus lakhs was already refunded by the accused person, in which the complainant is disputing that I am to say only 9 lakhs is remaining to be paid to the accused, to the complainant. But the accused, the complainant is admitting.
Why the accused had refunded?
Lordship, failure of the
Work could
contract may be
could not be executed.
because neither the Lordship, neither this complainant nor this person is company, not the company. They are doing subcontract work as per this terms and conditions of the agreement. This is the issue here, issue involved in the issue. So when the contract failed because of any reason, then the complainant has filed a complaint FIR before the Simtu police station. Accordingly, he has been arrested. Kindly see the page number 18, annexure 4. What is the ground of arrest? Kindly see. Page number 18, annexure 4. In last paragraph.
Yes.
In last paragraph, page number 18, annexure 4 says. It is said that in the further course of investigation, Dheeraj Pao was served notice of under section 41A of CRPC on such as two instances, but he failed to comply, did not turn up in the police station. So given date and time, all reports were made to trace out Dheeraj Pao, but failed. It was revealed that Dheeraj Pao is deliberately evading police and investigation. In the next paragraph, in the further course of investigation, it was revealed that Dheeraj Pao had deposited some amount. Yes, it is admitted that 48 lakhs already, I have enclosed the copy as a bank statement. 48 lakhs already deposited in the account of the complainant without his consent. When the contract this consent is not required because it is already when the contract failed, he was demanding back the money. It is not an issue here. As soon as he was served notice, and this was indicative of the fact that he was aware of the cases and still he had not turned up to the police. And then, from reliable sources, it was learned that Dheeraj Pao was hiding himself from police and temporarily residing at Guwahati. Later, the Honorable Court of Judicial Magistrate First Class Capital Complex was paid kindly issue non-valuable warrant against the accused person to produce. This is the issue. So what happened? He was arrested and he was taken on this police remand. Accordingly, his statement under 161 was recorded. And so when the police custody is not required, then he was sent for judicial custody. And still he is on judicial custody. And it is more than 30 days and 10 days. It is a 40 days plus days is already 11. And no custodial custodial interrogation is required in this case. This is the case. In the procedural aspect, there is no ground for further custodial interrogation. Since he has already deposed his part and the part payment has been already done, then the full payment can be done only when he is out from the jail. This is the issue. And that this is a completely monetary matter that can be managed when he is outside the that can be decided inside the jail. This is the issue. And this is the page number from 27 to of bail application, 27 to 40. This is the bank transaction in between the party. I have enclosed the copy. This is then now I am coming on merit because to make out a case under 420 IPC. 420 IPC on prima facie, the prosecution has to establish that this honest intention and one is dishonest intention, another is inducement. When there is a clear-cut agreement, where is the question of inducement? Where is their dishonest intention? When the party is making payment, repayment, he is trying to make repayment, and he is ready to repay the money. He wanted to buy time just to repay the money. And then when the money is ready, he will be given, and he can impose this interest. This is a failure, completely a failure of the contract terms and conditions. In that case, why he should be punished? Punishment is not the solution. In this case, that cannot be. Because they were the contracting party when they failure. This is a completely abuse of the process. That cannot be. There cannot be any room for harassment. Why there should be? When the parties enter in the agreement, when the contract fails, when already he has deposed whatever he can under 161, he was sent to the police custody and judicial custody now. Where is the further custody and interrogation? That is not required at this stage. He may be, therefore,
Yes,
he may be.
Your Lordship, firstly, I make a submission on fact, then I will rely the judgment, whether this judgment will cover this or not. Although this judgment is LV top 482 application, but Honorable Supreme Court has, Your Lordship, explained how 420 to 420 will come. It's not that if payment has been made, then initially payment has been made, then it will not be considered as if from the inception it is not there. Let us see this judgment, because so far as this.
May I complete my submission? May I complete my submission? I want to cite by this, my citation also.
Okay, what is that?
Let me complete my submission. Then only this part may be given. Kindly see, I have submitted this the Supreme Court cases.
Yes.
Why there is no criminal case under 420? Where prosecution has failed to make out, I am to say, prosecution has failed to make out case under 420 in the present case. When there is an agreement, when the allegation is he was hiding, he is avoiding. That cannot be the case. Kindly see in this case, Dilip Kaur versus Jahangir Singh. In this case, 2009, 14 HCC 696, and a para number 12 and para number 13. May I read para number 10 and para number 12? May I read the contents of para number 10? Para number 10 is seating, element of seating. Seating is an issue, and 420 is otherwise. Even then, may I directly come to the para number? Yes, para number 12. Yes, para number 12. The High Court, therefore, should have posed a question as to whether any act of inducement on the part of the appellant has been raised by the second respondent, whether the appellant has any intention to cheat him from the very inception. If the dispute between the parties was essentially of civil dispute resulting from the breach of contract, like this case, civil contract, on the part of the appellant by non-refunding of the amount. This is a case of non-refunding of the amount. Non-refunding of the amount of advance, the same would not constitute an offense of cheating. Similar is the case legal position in respect of the offense of criminal breach of trust, having regard to the definition contained in the 405 of the IPC. Doesn't care. When there is a civil contract, in this case also, there is a civil contract, there is a breach of civil contract. and which resulting resulted to the loss of the complainant when the contract could not be executed in terms of the agreement. There is a loss. So the losing party, affecting party filed a complaint for recovery of the money. That is the issue here. So in terms of law as well as because the prosecution has failed time and again, I'm submitting, failed to show any element of inducement, failed to show any element of this dishonest intention on the part of the accused person, because he is ready to pay at this stage also. When he can manage, he is mobilizing his resources for repayment. It is completely admitted. What can be investigated when the party is admitting? Only that is, money is only 92 lakhs, out of which some larger amount has been already paid. Something is remaining. That cannot be the case. Money cannot, this FIR cannot be filed for recovery of money. There is an alternative, there is a civil forum, civil court for recovery of money. Even then, without filing that civil suit also, I'm ready to pay because I know my responsibility. His money is with our account. That is the issue here. So at this stage, this prayer before this honorable court is that since no further custodial interrogation is required, because 161 statement has been already given and the accused is sent to the judicial custody. That is not required. So at this stage, he may be released on bail so that the remaining amount may be managed. And he will refund the money as and when the money is ready. This is the key.
Okay. Yes, Your Lordship. Nothing much to say from the record now, since my brother has cleared everything. So far as inducement, I will come to the judgment, Your Lordship. So far as inducement is concerned, he himself has prima facie established his case, because in Your Lordship will find in page number 21 the agreement itself. Page number 21, Your Lordship. I will come to judgment later, Your Lordship, so that I will clear the fact. Page number 21. Your Lordship will find his name, Mr. Dheeraj Pao. Right, Your Lordship. Here it says director. Now he is saying he is not director. This may be recorded. This may be not done, Your Lordship. Now he is saying he is not director, but in agreement he says director. This is the first ground, first thing which will literally induce any innocent person claiming to be the director. Now he is saying he is not director. And now second part is, he is saying he will ready to pay the amount. It itself shows his conduct. He itself is admitting that he failed to execute the agreement. And how he will execute the agreement if he is not a director, Your Lordship? So far as I'm stick on prima facie.
Whether you are, just a minute, whether you are director or not.
He is inside the jail for so many days, and I am unable to contact him also. Whether exactly he is director or not, I have been given a copy. I have enclosed also. I have a copy. This he's as per his appointment order. He is the chief executive officer of MS Rodas State Private Limited. Maybe
Whether
at that point of time he must be a director.
the statement of accused under 161 CRPC.
Can you see this?
Anyway, whether he has introduced himself as a director.
It's there, Your Lordship. It's there in the record.
Copy I have. It's appointed as chief executive officer.
Not director.
Not director. It's
Not
prima
director
facie
at that point of
established.
time. It was when it was
He impersonate himself, Your Lordship.
when agreement was signed. Agreement was 27 October 2022, and this it was of April. Maybe at that after this he might be a director. That is, I have to take instruction whether exactly he was at that point of time he was director or not. This is a private company. He may be a director. He may be a chief executive officer, and that is not a dispute in this case. They are not saying not as a chief executive officer, but he is seated as a director. It is not the case. case is there, he has not refunded our money. This is the issue.
Now, so far as money is concerned, I will come to the judgment, Your Lordship. It will show its conduct, and conduct is an ingredient for, now Your Lordship, 420 is evolving, your Supreme Court is now elaborating how to look into this aspect, because in many commercial transactions, this offense is committed. And because of the monetary transaction is involved, simply they come and say it's a civil dispute. Now, Your Lordship will kindly come to the judgment of 2024 SCC online, SC 2820. Your Lordship, I will read out the fact, because we have to analyze from the fact. Para 3 is the fact. The appellant original complainant filed an application under so and so, alleging that the second and third respondent, original accused, offer to take appellant's truck on a monthly rent of 33,000, exclusive of driver helper salary, for plying in between Tata Steel Jamshedpur and Kalingnagar. Pursuant to that offer, an agreement was entered. Here also agreement is there, into between the appellant and the accused on so and so, thereby letting the vehicle to the accused for a period up to 31/3 so and so, with effect from so and so, and in furtherance thereof, the possession of the trucks was given to the accused. In return, they paid 1 month rent. 1 month rent is paid, Your Lordship, after deducting TDS, but thereafter, though the truck has been in possession of the accused since July 2014, rent including arrear amount of so and so was not paid to, despite repeat false assurance. This was the allegation, but considering that allegation, this High Court has quashed this matter on the ground that he has paid the initial rent amount. From the inception, there is no any fraudulent intention. That has been explained by the Supreme Court. Your Lordship will come in para 10. B. I will read from B. Admittedly, 1 month rent was paid. Therefore, dishonest intention from the very beginning was not there. The application is only for recovery of rent, which can be realized by taking course of appropriate civil proceeding. Hence, no offense punishable under 420 is made. This was the observation of the High Court. Now, Your Lordship will come to the finding of the Supreme Court in para 17 and 18. To commit an offense, unless the penal statute provide otherwise, mens rea is one of the essential ingredients. Existence of mens rea is a question of fact, which may be inferred from the act in question as well as the surrounding circumstances and conduct of the accused. As a sequitur, when a party alleges that the accused, despite taking possession of the truck on hire, has failed to pay hire charge for months together, while making false promise for its payment, a prima facie of dishonest intention on the part of the accused is made out, which may require investigation. In such circumstances, if FIR is quashed, now so far as quashing is concerned, but Your Lordship, I'm just on the ingredient, Your Lordship. Inception, it would be nothing short of an act which toward a legitimate investigation. 18. It is strict law that FIR is not encyclopedia of all imputation. Therefore, to test whether an FIR disclosed commission of a cognizable offense, that is to be looked at not only any omission in acquisition, but the gravamen of a acquisition contained therein, to find out whether prima facie cognizable offense has been committed or not. At this stage, the court is not required to ascertain as to which specific offense has committed. It is only after investigation at the time of framing charge, when material collected during the investigation are before the court. The court has drawn an opinion as for a commission of which offense the accused has been tried. Prior to that, if satisfied, the court may even discharge the accused. Thus, when the FIR alleges dishonest conduct on the part of the accused, which if supported by material would disclose commission of a cognizable offense. Now here says investigation. I clearly submitted it's a LVT of quashing petition. But so far as 420 is concerned, the Honorable Supreme Court has clearly says, Your Lordship, the conduct and the circumstances has to be looked into. Now he is clearly submitting that I am ready to pay the remaining amount. Meaning thereby he is admitting he has initially introduced himself as a director for a work, and in pretext of this, he had taken certain amount from that person, and which was executed in 2022, and Your Lordship will find the FIR was registered in 2023, and in the meantime, he was absconding, he was evading arrest, Your Lordship. And now in 2024, when he was arrested, all of a sudden he comes and say, I'm ready to pay the amount. It clearly shows his dishonest intention and conduct, Your Lordship. And so far as Your Lordship custodial interrogation is concerned, the status reports clearly shows why his custodial interrogation is required. Moreover, he is a habitual offender, Your Lordship. And the documents need to be collected, and the monetary transaction, Your Lordship, has to be verified. Where he has sent all this money, Your Lordship, other accused are involved or not, whether he himself have done all this act or not, Your Lordship. That has to be find out, Your Lordship. On that aspect, I have an objection.
This accused person is inside a custody only in this case, or he is inside a custody? in
Earlier,
connection with
he
some
was
other
in
case?
other case, your lordship. By the time when he was in judicial custody, this through production warrant he has taken in this case, your lordship. And now, after this matter, your lordship, the Pasigat case will come where he has applied for anticipatory bail. It is clear before your lordship that in many occasions, in many times he has committed an offense. He's an habitual offender, your lordship.
Encouraged by the people like the president.
Yes.
Lordship, this
See,
is not a
it's
quasi.
not a small amount,
Yes, your lordship.
40, 50, 40.
An agreement, your
investment and then without.
lordship, we ignore the date when it was executed, 22.
And then-
FIR was registered in
And then
23.
Interestingly, in the agreement, I could see the confidentiality and non-disclosure.
Yes,
What is this?
yes.
So each party agrees to keep secret and confidential. See, both party.
Yes, your lordship.
Lordship, this is not a quasi petition, first of all. Matter is to whether.
No, the
custody- further
intention,
custody-
Intention, I'm just drawing the
conduct,
intention. I'm
conduct.
not on quashing. I'm just drawing the intention.
So
The ingredient.
conduct of both the
Yes.
parties, not only the accused. Anyway, so,
If the man is out from the judicial custody, only then he can manage, because he is a responsible person,
Mr. Kappa.
family man.
This is item
Item 11.
11. Okay. Okay, David Kappa, land counsel for the petition. I've also had Mr. PAP, land additional PP, state of staff. This is an application under section 439 of the Criminal Procedure Code, 1973, under section 483 of BNS 2023, praying for the grant of bail to the accused, Jurisdictional, who has been arrested and detained in the police judicial custody since. Who has been arrested in connection with? Who has been arrested in connection with the Chinku PS case number 9/2024 under section 420 IPC. So you filed bail application before the magistrate.
Yes,
It was rejected recently only.
yes, not exactly recently, but his application has been rejected.
Have you annexed the rejection order?
I have page number 2. There's a para number 2, page number 3. I have shown the ground. I have applied the CTC of rejected application, rejection order. But the magistrate refused to furnish.
Refused to furnish.
Not furnish, he is not saying nothing, any comment. I have applied. Kindly see page number, this, page number 41, annexure 8. This is my application. Bail application number 265, date of order is 23 October 2010. And I have filed this application on 23/10/2010. Then after waiting for so many days, I have to file this application because the man was inside the jail. I cannot wait anymore. The reasons has been cited in the para number 2 of my bail application. Why I have not enclosed that order? What may be the reasons of non-publishing of that bail order by the judicial magistrate plus first class UPR? generally, in practice is that today I have applied, tomorrow that will be made available to the advocate of the case. But generally, it is not done before the judicial magistrate first class is here. There are so many complaints, not only against the judicial magistrate first class is here. Maybe against the staff. Yes, maybe against the staff. There's quite a repeated approach for punishing of the file was kept inside the chamber. Paragraph to have stated that. It is stated that the petitioner says for the release of the bail application number as filed and the center disposed by the judicial magistrate first class will be on 23rd October 2000 by rejecting the bail.
The place of the petition is that 1-3 Jumda Padu lodged a written FIR against accused Dheeraj Pal for fraud and cheating, alleging that the accused introducing himself as director of MS Road Estate Private Limited and approached him for financial assistance to carry out the installation of Airtel tower works in the state of Arunachal Pradesh. Thereafter, they provided finance for the said work according to the terms and conditions of the memorandum of understanding executed by them on 27/10/2022. So accordingly, they arranged funds amounting to rupees 92 lakhs only for the purpose for the said purpose and handed over to the accused in his account, deposited in his account.
Account number is given the
It's in his
amount
account.
to Dheeraj Pal on the
Stop.
bank account numbers are there. And see whether.
However, the accused has failed to fulfill his commitment and has not returned the funds provided to him. So the accused is evading communication and has shown no intention of repaying the amount, indicating a clear intent to defraud. So it is further alleged that that it has come to light that the accused is not the director of the Messrs. Road Estate Private Limited. So, basing on the above FIR, the police has registered the above ES case against the accused under section 420 IPC. it is submitted that after registration of the case, the police has summoned the accused. He appeared earlier.
Yes.
Summoned the accused under section 41A.
He never summoned, I never
appeared.
didn't appear, but I was arrested, so I appeared.
You never appeared.
No, never appear, Your Lord.
Two
Okay.
times I was summoned.
Okay. Okay. So, issue summon against accused for his appearance. Summon under section 41A of CRPC for his appearance, requiring his appearance on 12/2/2024 and 1/5/2024. Why you did not appear?
Because there was so many demanding parties.
Okay, however,
For waiting for
however, the accused failed to appear before the eye of the case, and as a result, the accused, Virat Pao, was arrested for on the ground for not cooperating with the investigation process staff. The case of the petitioner is that
Paragraph 12 of
what is that?
It is how much amount has been given, is repaid, it is written. Out of 90.
48.
48 already paid. That is
Okay.
admitted also. Admitted by on the basis of bank transfer.
The case of the further case of the petitioner is that from mere perusal of the FIR come the allegation, the allegation against the accused is of civil allegation against accused is of civil nature, where the informant has extended monetary finance of rupees 92 lakhs for executing what work?
What was this installation of Airtel towers as a subcontractor?
For installation of
Airtel tower.
Airtel tower as a subcontractor. However, during the pendency of the investigation, the accused has already repaid a sum of rupees 48 lakhs. Only 48 out of 92.
Yes, 48 out of 92. And I am also claiming that another 35 lakhs was also refunded to him, but by way of adjustment. But this company is disputing over the 35 lakhs. No, my clearly admitted amount, liable amount is only 9 lakhs in this case.
And some 35 lakhs
is disputing.
Were also repaid to the informant, although the informant disputes the said amount. So, according to the petitioner, the learned counsel to the petitioner, the accused now is to pay a refund
Nine lakhs.
only about 9 lakhs to the informant. Which according to the petitioner can be refunded if the accused is released on bail. The further condition of the petition is that since the police has thoroughly investigated and his statement has also been recorded, no further custodial interrogation is required. And no further custodial interrogation of the accused is required. And hence, therefore, is released on bail. You are relying upon the paragraph.
Paragraph 11 and 12 and paragraph yes, paragraph 10, 12 of my citation.
In support of his submission that the case is purely of the civil nature, the learned counsel for the petitioner has relied upon the decision of the Honorable Supreme Court in Dilip Kaur and other Jagnar Singh and another
2009-14 is
reported in 2009 5 Supreme 368.
Yes, it is para number 10 and 12.
The relevant paragraph, para 10 and 12 is reproduced here in 10 and 12. Right. Mr. KT, Sergeant Additional PP, on the other hand, they produced the case, the case diary, with the status report. And while referring to the case diary and the status report, submits that from the very beginning, the accused has an intention to, from the very beginning, the surrounding circumstances and the conduct of the accused, it is clear that he had an intention to cheat the informant. And while introducing himself as director of Messrs. Rhodes Estate Private Limited. He has got a sum of rupees 92 lakhs deposited in his account. For execution of the work. What is the work?
Work is we have to installation of airfield tower.
For installation of Airtel tower. Yes, who is the subcontract?
Actually, this MS Rhodes.
For carrying out the
MS Rhodes
sub
private limited is the
subcontract, carrying out the subcontract for installation of the Airtel tower. However, the accused failed to. So this is, as per this agreement, is there any clause for refunding of the amount?
It is clearly stated that as per the agreement, place of jurisdiction in case of any dispute, dispute governing laws, page number 45.
Refund is not there.
Kindly see.
Is there any clause for refund? Page 45.
What is the
Page-
page number 45.
There is no 45.
Page number
45. 45.
Page number 45 is not there.
You have only about up to 41.
41. Page 23 or 24. 25 is the last signature part. 24 condition confidentiality and disclosure. And responsibility. There is no any clause for refund. Your Lordship. Let me see. No clause for refund.
Yes, not refunded till date. Okay. It is further submitted. The investigation of the case reveals that it is further submitted that the investigation of the case is still at the nascent stage, and the involvement of other individuals are also need to be ascertained for proper investigation. The land counsel for the land additional duty further submitted as per the records. The accused Dheeraj Pao is involved in multiple cases of the similar nature. Cases of the similar nature. Like Vita PS case number 8924 under section 120B 420 34 IPC. Number 2, Devamali PS case number 0524 under section 406 420 IPC. Number 3, CR case number 2024 under section 138 142 NI Act, etc. And since the case is still under active investigation, we raise an objection for grant of bail to the accused at this stage. In supplement, this may not be required.
Not required, Your Lordship. I'm just demonstrating the ingredient and Your Lordship has reflected it.
We already reflected. Ask for the land counsel for the parties. The submission advanced by both the land counsel for the parties. Upon hearing the parties and on perusal of the records, it appears that the informant has it appears that the informant and the accused, Dheeraj Paul, had entered into agreement by executing memorandum of understanding dated 27/10/2022. And in person to the said memorandum of understanding, the informant had invested an amount of rupees 92, amount to the tune of rupees 92 lakhs by depositing the same in the account of the accused. No, not accused. Messrs. Neri Engineering. No, it's not Neri Engineering. Neri Engineering is, this belongs to the informant.
Informant, one of the informant, as per this, Neri Engineering has, paid a sum of rupees 42 lakhs.
Okay,
And,
okay.
50 lakhs was given by Junda Pada. It is, there on joint venture. 2%.
Okay, pursuant to the said memorandum of understanding, the informant has invested 50 lakhs and one Messrs. Neri Engineering has invested rupees 42 lakhs by depositing in the account of the accused staff. However, in the meantime, why he has lost this FIR? Whether any demand notes
Demanding the money for refund.
refund?
Refunding the money.
They first demanded.
They demanded.
You did not refund.
Because I was not in a position to repay the money.
Okay,
Because there was no money.
Okay, so
That is why I could not
the work also could not execute.
As far as I can, I have repaid for up to 48 lakhs. But
Okay.
and out of 92, I could not.
Okay,
fulfill
however,
the-
during however, prior to filing of this FIR, whether the informant has demanded anywhere, is there any document showing that they have
No
demanded
documents, but
directly
per-
file FIR?
not they were asking the refund of the money. So on the
Okay.
basis of their mutual discussion, they have on the various bank transactions, they have.
However, due to the dispute
Kindness,
arising,
page number
however,
20.
due to the dispute arising between, in any case, dispute arising between the parties, the informant demanded back the money invested by them from the accused, to which the accused failed to refund on time. And on his failure to be refund, the informant has lost the present FIR, resulting registration and his arrest. Staff. Admittedly, during the pendency of this case, the accused has already deposited, repaid a sum of rupees. How much you said? 48.
48 lakhs
48 lakhs
by bank transaction.
to
Your lordship will verify from the this statement of the complainant also, because it is whether admitted or not, your lordship.
So I think we have seen somewhere.
It is their version. It is the statement of the accused only, your lordship.
Kindly see bank transaction, page number 20. Direct account to account transfer it is. Account, page number 20. Kindly see page number 28.
28.
28. Yes, down below, second, last and third last. RTGS in favor of Junda party.
Okay, by depositing in the account of the informant
So many lakhs.
and as and
Amounting to total amount is inclusive of all, it is 48 lakhs.
and accused while admitting the
Remaining amount.
admitting that around 9 lakhs is yet to refund to the informant. He is ready to refund the same if he is released on bail. Considering the nature of allegation and considering the nature of the agreement entered into between the parties and the allegation made by the informant, it appears that prima facie it appears that the case is of civil nature, except for the allegation that the accused introduced himself as director when he was not. When he was not, which
For this particular point, I had to take instruction before.
which is still under is also which is still under investigation. Which is also still under investigation. Stop. In view of the above and considering the entirety of the case, I'm of the view that the bail prayer for his release, bail prayer for release of the accused can be considered by imposing certain conditions. Stop. According to this bail application is allowed, the accused is directed to be released on bail on execution of a bail bond of rupees 50,000 with two surety of like amount to the satisfaction of the it would be a satisfaction of the
Yes.
who?
Satisfaction of the judicial magistrate first.
Okay. Of the judicial magistrate first class.
Yeah.
With the following condition. Stop. That the accused shall appear before the cooperate and appear before the eye of the case as and when called for. That next that the accused shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case, so as to dissuade him from disclosing such fact to the court or to any police officer. The accused shall not leave the jurisdiction of this is Itanagar PS case.
Itanagar PS, not Itanagar,
Imbu PS. Okay. Jurisdiction of the judicial magistrate. It's tribal by judicial magistrate.
Yes,
Judicial magistrate first class without
Prior permission.
the previous permission of the court, of the state court.
You have to cooperate with the investigation.
That is there. Cooperate with this appear before him as and when court. Whatever this well application is allowed in this project.
Next,
No, this is AB, same accused.
this is, I am suffering from this similarly situated case. Because in this FIR page number 17, in this case also I was representing as, although I have been shown as a proprietor by this, the complainant, in the page number 17 annexure.
Where is it? So,
Page number 17 of the this mail application. This is the FIR.
this is at about the same time.
This is the same situation. It was in September,
No, it's in Pasigat, your lord.
Pasigat PS case.
Okay, here he is.
This MS Rodas Private Limited was working at Pasigat.
This is not the same farm.
This is the same firm.
Same
MS
farm.
Rodas State
He
Private Limited.
is here. He is
MS Rodas State Private Limited.
no. He what under what capacity?
He was chief executive officer at that point of time, but the complainant has said he was the proprietor. Exactly, it was not the case, but it may be the misunderstanding of the fact.
You
In
have the
this case,
scanned copy of the
during-
case, Hari?
Yes, your lordship.
What? Anything?
Your lordship, here in this case, your lordship, even the IO has prayed for your lordship this production warrant of the accused, because in this case he has not been arrested as on that.
Okay, he has
Because he is
paid
in
for
custody.
production warrant.
Yeah, he is in custody of.
Now probably he will be able, he'll get him.
Yes, your
The
lordship.
accused will be produced before him and then he can arrest.
Yes, your lordship. So far as your lordship, the BA is concerned
Ah.
regarding your lordship, the considering material on, he has been granted bail, your lordship. But
Ah.
so far as this case is concerned, this is a privilege of anticipatory bail.
Hmm.
And as your lordship has also found in that case that prima facie case is there. Here also prima facie case is there. Here he has introduced himself as a proprietor. At least to have
So,
introduced.
Now, in the earlier case, he
was
not
director.
but he introduced himself as director.
Yes.
And here he has introduced himself as a
Proprietor.
proprietor. How much, what is the amount involved here?
80.
80
lakhs.
lakhs.
80 lakhs. That is the margin of the complainant. It is 80 lakhs only.
Now here the your lordship, the investigation is at nascent stage, your lordship.
Let us see the FIR first, no?
FIR is in page number 17, your lordship.
Okay, here the co-accused is involved here.
Yes. Here he has, your lordship, the promise to provide him the tender work, your lordship, of construction of telecom tower.
Same connected matter. Not
Telecom
exactly
tower.
connected, but this is also.
Your lordship, the FIR clearly disclosed, the other record clearly shows, he is a habitual offender, your lordship. And it's a privilege of pre-arrest bail, your lordship. This is not a regular bail. He is not entitled for privilege of pre-arrest bail, your lordship. FIR itself clearly disclosed.
A line of argument in this case is lordship.
The amount was transferred to his account, your lordship will find it FIR also, not in the farm's account.
All this,
Means transfer in the farm's account, then inference can be drawn, your lordship. Yes, his intention was. He's representing the farm, but here he is introducing he is a proprietor and his own account amount has been transferred.
he said, I am not going to refund the money. Another step, representative capacity.
If your lordship,
Admits the fact that money is to be refunded.
every time if of the offender says that I will refund the amount, then even I will start making promise to the others and take crores of money. Then later on, if they file bail application, I will say I will refund the amount.
The question is that now, you see, one has to have a charismatic power. Like this one.
Yes.
One more submission.
So there's the money invested in such huge amount.
Yes, your lordship.
During the course of investigation in this case, this previous case, my bank account has been freezed. That is one of the ground why I could not refund the money.
Here, your lordship, the question is not regarding refund. For civil, your lordship, damages can be claimed through civil proceeding, your lordship. But so far as simultaneously the criminal offense has also been committed, that has to be taken into consideration. This is for punishment. CR IPC is for penal provision, your lordship. It's not for damages. No doubt later on they also have a remedy to recover it through by a civil proceeding, your lordship. By
There
filing.
also there is an agreement again.
But that is there, your lordship. I have the judgment which I have relied on, your lordship. There also the agreement was there, your lordship. But Supreme Court says, your lordship, the conduct, your lordship. And your lordship, from the inception, it can be clearly I can establish from the FIR itself how a company, whether they can show that the Rhodas company have any tender or they have the authority to provide any tender work for construction of tower. If they showed all these things, then it can be said that prima facie that there is no any for the purpose of bail, your lordship, no fraudulent intention, dishonest intention. They are simply saying they will provide a tender work for installation of power. They are not saying we have the authority. They have to show that they have the authority to provide that installation of capacity to provide a subcontractor or any other person for installation of tower. They are not saying so. They are simply saying we are farm, we are corporation, and I am the representative of that corporation. I am doing this and that.
In this case, MS Rhodas Estate is the actual contractor. And the rest of the contract work was under subcontractor capacity. Subletting the work.
If anything on the record, they can show that yes, the Rhodas company, they deal with the installation of the tower.
Knowing that he is in the jail, why the IO is not showing him?
Your lordship,
Showing him arrested?
it is well settled, your lordship, in this Anupam Goswami matter, the Anupam Kulkarni matter, your lordship. The IO can show formal arrest also. Without showing formal arrest, IO can go for PT, this production warrant. The IO is approached for production warrant, so formal arrest is not required. Formal arrest is no doubt for frustrating the anticipatory bail. But your lordship, the application is made before the concerned magistrate is reflected in the case diary. And perhaps the magistrate was on, she was on leave. Now, if production warrant is given, then definitely he will be produced before the magistrate, your lordship. And accordingly, the magistrate will decide whether to give police remand or not, your lordship. It is not a case that police is not want him for investigation. And police is accordingly, your lordship, comply the procedure, your lordship.
What is this? Here also you have annexed the FIR laws against.
FIR goes against this Mr. Dhiras Pawar.
There by Jumda Paru. This is in the earlier case.
Yes.
Page 19 is in the earlier case, FIR of the earlier case. Is it not?
Earlier case also was against the Dhiras Pawar as a representative capacity. Allegation, only difference is there. In this case, it is in the complaint, it is said he was representing in the capacity of a fighter, but in the earlier case, it was a director. That was the only difference. In this case, I have to suffer in case of his own arrest. In that case.
In which case he is inside?
Now in
the
the,
other case.
no, in Jomali case, Your Lordship. Jomali,
That is different.
that is different case again. Your Lordship will find in their
Okay.
page.
So now he is inside a custody in
Yes,
both cases. The Amali and this, the earlier case.
Earlier case already released, Your Lordship, and in now in
He was inside in
yes,
two
sir.
cases.
Yes, yes.
Okay.
Your Lordship,
Now
actually,
the other
initially in
case
Chimpu
released.
case, he
In
was
the
arrested.
Nepali case, how long he has been inside the custody?
Normally case, it must be, it is also about the,
10, 15 days.
20 days.
In Your Lordship, Chimpu matter.
In any case, he is, even if we, the.
Yeah, even- yes, Your
grant bail
Lordship.
Also.
Now, in Chimpu matter, where Your Lordship has granted bail, there he was in judicial custody. Well, production warrant has been, as per the instruction, production warrant has been issued by the concerned court, and he has been taken to the custody of the Devamali police station.
Okay.
So
Now,
now-
in the instant case, in the present case also, he can done that.
Yes, Your Lordship. But after during the judicial custody only, during the police custody, Your Lordship, we cannot so.
Now he's not in the police custody.
He's in judicial custody. Yes, Your Lordship. The production warrant has already been applied before the court, Your Lordship.
Oh,
Even in that case,
okay.
production warrant was
Not yet issued.
not yet issued in this case. If issued, then this concerned police IO will take him to the custody and do interrogation.
But what purpose it will serve? Because he's in jail, inside a jail only.
Because
Yes.
in case of lordship, in case of his arrest again in the Pasigat PSK, then I have to suffer. Not less than if it is not released early, it maybe goes up to.
Okay,
60
you are
days.
clearing one by one.
One by one clearing, Your Lordship. Yeah, but Your Lordship, in my, I'm objecting this bail application. It's anticipatory bail. Otherwise, if he was arrested, but if the investigation authority has not given an open hand, Your Lordship, it will be difficult to unearth the truth. No doubt, Your Lordship, it is very clear that in many places he has committed an offense. But for that, Your Lordship, now even from the record itself, it is very clear, Your Lordship, his modus operandi, how he allure people, and how he obtain money. And later on, when he caught, he said he will repay the money. This is his modus operandi, Your Lordship.
This, I am Prime Minister submitting it is on a representative capacity. That is why, when you are an employee of the company or the firm, we have to do anything what master command.
You are the faithful servant.
Yes, faithful servant.
Doing unfaithful
Good.
work.
Doing sincerely, of course.
Sincerely doing unsincere,
And very
illegal work.
So now here also you see it's very difficult. It appears that it's not exactly the criminal case also. There is an agreement.
Your Lordship, that is Your Lordship. That is why Your Lordship, I have produced the judgment of the Supreme Court. There also agreement was there. There was agreement between the party for hire of the truck. But Your Lordship, on the
They have, you see, the known farm.
But Your Lordship, the question is that
Rhodes estate.
that Your Lordship,
known to everybody. it appears.
the question is that whether Rhodes company, they have that power or they have that work under their control to offer that power to anyone. If it was the state government, supposedly, Your Lordship, it is for road construction. If I do not have any authority, if I promise my brother, say, okay, I will give you a tender work, whether that will sustain, no. It is the state government or the central government who had the work, who float a tender and give it to the other person or the contractor. The same here, Your Lordship, regarding installation of tower. If agreement itself is, Your Lordship, illegal, that is the subject matter of the investigation. Whether the Rhodes Corporation, they have that much authority or infrastructure for the installation of the tower. Whether the Airtel have given him that much authority or there is an agreement with the Airtel for installation of tower or not. Your Lordship will clearly see in the FIR itself, the tower has been installed by some other contractor, Your Lordship. Now, Your Lordship, they are demonstrating, they are saying that because there is an agreement, there is civil dispute. Later on, Your Lordship, during the trial, because of this.
What the case diary says?
Your Lordship, case diary, Your Lordship, he is in the custody of the other, it is Your Lordship, so far FIR, regarding the FIR, it's a verbatim of the FIR, the statement of the informant. And so far as the other statement investigation is concerned, investigation is told because the person is in the custody of other police. He has PT warrant has been applied before the concerned court. If PT warrant has been issued, then your lordship, his statement, everything can be recorded and document the document where he's kept the document, because your lordship has already seen in the earlier case, he has not produced the document. Despite being saying that it was with him, he was not produced the
Now
document.
he's in jail now.
He's in yes, custody of your lordship.
It's difficult for him also.
Yes. Now, if supposedly your lordship, if lordship is convinced and grant the bail, how he will execute the bail? How he will cooperate with the investigation if he's already arrested? Your lordship has to release him from in the Demaji case also, or this Diomali case also. How he will appear before the IO and give his statement until or unless he is really yes, yes,
Taking one by
he has
one.
to take one by one, or otherwise altogether. Then your lordship, if he is released in Diomali PS, then court can direct him to appear.
He is expert on. He is to be released in all the cases first.
Yes, your
so
lordship.
that he clear the bills.
Yes,
clear
your
the liabilities.
But that is only, your lordship, in my humble submission, your
Anyway,
lordship, that is only
what
purpose
to
for
do?
the FIR.
Pass order after.
Yes.
Maybe fix on, maybe we fix on Monday.
Monday?
Some urgent work.
Okay.
Okay, your lordship, let it be on Monday. And then in that case, your lordship, case diary may be written and call for the fresh one, updated one.
For by the Land Council for petition. This is matter again on Monday.
Your lordship, let it be on Tuesday. your lordship.
Tuesday.
Yes.
Okay. In the meantime, return the case diary
Yes. And
to be produced on
next
Tuesday.
yes. Updated case.
To be produced updated CD on Tuesday.
Yes, your lordship. Deeply obliged, your lordship.
Lordship,
This is 12.
yes, Lordship. I was supposed to appear at item number 8, Your Lordship.
Yes.
But then I got to learn that item number 8 has been mentioned by the state. Item number 8, Your Lordship.
Yes, yes, on behalf of the special PP.
Yes, the special PP,
Yes.
not the special PP.
Your Lordship, my attendance may be recorded. I am appearing on behalf of the respondents.
Your presence, your presence.
Yes, Your Lordship. Yes, Your Lordship.
Okay, then in that case, item 8. It was adjourned. Mr. C.W. Mantho was appear through VC, huh? Okay.
Your Lordship, I'm unaware of the date, next date, Your Lordship.
Next day, I don't know. It was after 2 weeks.
It's all right, Your Lordship.
Okay.
It's all right. Obliged, Your Lordship.
At 2.
Yes,
May I please, my lord?
Yes.
My lord, I beg to mention item number 23 because there is an urgent call from the warden of my son, Petitanagar.
Item
23, my lord.
23. What you want?
Maybe at least after 3 weeks, my
After
lord.
3 weeks.
Yes, my lord.
Let's pray for by Mr. Nilam Kaji, Land Council for the applicant. List is matter after 3 weeks.
Yes, my lord. Okay. Oblige me.
Your Lordship, I'd like to mention item number 16
16.
on behalf of Hendy Jera.
It will be called now, only wait for some time. We'll see the record and pass order. Are you in urgent? Urgency, is there any urgency?
No, yours.
Okay. So afternoon is not a mentioning time, unless there is an urgency. Okay, please. Yes, I think this is 13.
Yes.
Yes.
Lordship, I have already taken my sister to the respondent number 2 and 3.
You are correspondent?
No, petitioner.
You are for a petitioner?
Yes. I've already taken
steps.
Steps to the respondent number 2 and 3.
Unserved notice. It has notice has been not served upon respondent number 3. So report in respect to of respondent number 2 has come back, but then in respect of 3, it has returned unserved. So what do you want? You want to take fresh steps or what? No? Why it has come back?
No, Lordship, I don't know, Lordship. I'll take fresh step again.
Just a minute, huh? Okay. He has refused to receive. What is this case? Criminal revision. Yes. So,
Last occasion, Lordship, it was served to the OCPS of the concerned.
okay. Uh, Mr.
M. Lego.
M.
Lego, L-E-Z-O.
Lego, Land Council for the petition. About your hard Mr. Land additional people. Additional people.
That's right.
Okay, stop. For the state, huh? Stop. The office note dated 1/11/24 reflect that service of notice upon the respondent number 2 has received after closing of service. So sorry, service report has been received after closing service upon the respondent number, closing of service, closing service of notice upon respondent number 2. And the service in respect of the service of notice in respect of respondent number 3 through OCPS Janagar return unserved with a comment that the respondent Sri Kamlesh Kumar Rai has refused to receive the copy of notice. Yes, Kamlesh. Who is one? One is state.
I is that.
Okay. In view of the above, the service of notice upon the respondent number 2 and 3 is treated to have been complete. Stop. No one appears on behalf of the respondent number 2 and 3. Stop. This is listed over here. Order.
Yes.
Okay. List this matter after 3 weeks for admission. Okay.
Your Lordship,
Yes.
I have just telephonically informed at that lunchtime.
Telephonically informed to whom?
Just now.
Whom?
By this conducting council.
Okay.
Inti Jaram.
So he is not appearing.
Yes, Lordship.
Okay. You are Mr.
Korabdai.
What appropriate application must be. Okay. By an order dated 26/9/2024. The appellant was asked to file appropriate application for condonation of delay. However, no such application has been filed till date. So, today, Mr. You are Mr.
Torab Dai, T Dai,
T.
Dai.
Dai submits that the Lara Council for the appellant is Hinti Jeram
Yes, Lordship.
could not appear in the court due to some personal difficulties and prays for adjournment. Prayer allowed. List this matter after. Meantime, the appellant may file appropriate application for condemnation of filing the connected appeal. Okay. No, file the condemnation not connected appeal. Condemnation of delay is for the order dated 26/9/2024. Okay. Yes.
Lordship, may be allowed to take fresh step.
You want to take fresh step?
Yes.
Phone? Okay. In view of the office note dated 12/11/2024, Land Council for, you are for the petitioner?
Yes.
Land Council for the petitioner, prays for allowing to take fresh steps upon the respondent number 5, 7, and 8.
Yes, Your Lordship. 5, 7, and 8 were not completed.
The prayer is allowed. Step be taken to office of the PP UPR. PP UPR within a week from today. List this matter after 3 weeks.
Lordship, item number, I think my brother is wrongly appeared. Item number 17 is my.
Okay.
In compliance of order dated 23/8/2024, I've already taken the step upon
That is,
respondent.
we need to see the record.
Yes.
Okay. Yeah. You have taken steps
Yes,
upon respondent number 5, 7, and 8.
yes.
Okay.
In that case, await for the service report, Your Lordship.
The service of notice upon the office note dated 12/11/2024 reflect that the service of notice upon respondent number 5, 7, and 8 is still awaited. In view of the above, the case can adjourn. List this matter after 3 weeks.
3 weeks, Your Lordship.
Interim is your Lordship, interim will come.
Stop. Para. The interim order pass RDS shall continue till the next day.
Lordship, we have been taking the steps since 2023.
Ensure that it
Yes.
reaches them. After that, we'll treat that the service has been completed.
Yes.
Then we'll
Now we
proceed.
have already taken 9th time
Is it?
so far, yes. First service was taken on 28/2/2023.
Not yet received, not yet received,
Yeah.
awaited.
Let them
These are
verify.
the report.
Let them verify the address then.
You probably has to verify the address.
Yeah.
It was taken through PP.
Yes, last by order dated 23/8/2024.
Now, let us wait this time.
Yes.
Since this one, it was taken through PP, through OC, I think, the report.
We have not received any, Your Lordship.
Even in trial court, Lordship, these the private respondent, they didn't appear. That's the reason
This is
the
criminal
petition is
petition.
for you.
It's a criminal
Criminal
petition.
petition for quashing.
Yes.
What is the allegation against accused? The petitioner? This is not a joint petition.
Your
No, not a judge.
Your Lordship, in fact, the respondents are from Assam.
So many respondents.
Yes, respondents from Assam and Manipur, Your Lordship. So it has to
Then
be
we need trouble.
taken from the jurisdictional police station, Your Lordship.
It has to be.
Yes, Your Lordship.
Now, already that step has been taken by
Through jurisdictional police station.
Yes.
Yes, Your Lordship.
But so far there is no any.
At least there must be some remark whether
What,
they.
what is the offense alleged against you?
448, 326, 34 IPC, Your Lordship.
448,
Yes,
326.
26. Yes, grievous.
The trouble,
Yes, and 30 for common intention.
34. The incident occurred in which year?
2016.
16. 16 case.
Yes.
What is the stage of the trial?
No evidence, Lordship. But this, the private respondent, they didn't appear, and even the notice could not be served upon the private respondent by the learned trial. That's the reason the petitioner is.
Someone was issued.
Yes, Lordship.
And then thereafter, any warrant against
Yes,
him?
Lordship, warrant was issued.
Warrant was
Yes,
issued.
2 times warrant was issued on 2 occasions.
Then probably here in this case, in this code also probably, it is unlikely that they appear.
Lordship, here the case is that the private respondent, they were applying laborers working under the private respondent number 4, Lordship.
Respondent number 4.
Yes, private respondent number.
Whether private respondent number 4 appeared?
Yes, they have already entered there.
Okay, then the victim, who are the victim?
This private respondent.
Private respondent, no?
Yes.
4 is not the victim. 4 is not the victim.
No.
He is only informant.
Yes, he is only informant. Under his.
Now the 4 can report, I think, reported they are untraceable because it was, they were working under respondent number 4 only.
No, Lordship, that endeavor also we have exhausted.
Whether the 4 appeared before the court?
Yes, Lordship, they have already filed.
Whether he has deposed before the court?
They have already
He
filed.
has given his evidence.
Yes.
What he stated about the other witnesses?
No, to this aspect, they did not file any evidence, but they have filed their evidence.
Now their address is also with the respondent number 4 only, I think. Address of the laborers.
They were engaged by the respondent number, although they were engaged by the respondent number 4, but they were applying laborers working in various districts of the state of Arunachal Pradesh. At that point of time,
it would be really difficult. Then under such circumstances, if they cannot be found out after the issuance of all those, then probably the trial court may proceed with it.
Lordship, the matter has already settled before the customary court also.
Involving with this
Yes,
private
Lordship.
respondent also?
Yes.
Are they signatory to the
Yes, Lordship. Yes, Lordship. They have received the compensation amount of 50,000 each.
So now whether the trial court is proceeding further now?
No, Lordship. The proceeding is.
Since when?
Since 2022, Lordship.
23, because of non-appearance of these witnesses.
No, Lordship, because of filing of this instant petition.
Whether they are
Matter is stayed. And because of stay in this case, Your Lordship, the learned trial court cannot also take any step further, Your Lordship, to ensure their
difficult.
Lordship, I kindly come to the page number 22 of my petition.
22.
Yes. This was the cover decision.
No, who are these? The respondent number?
Difficulty here is whether the Kava has the jurisdiction to try all this matter or not. That will be the issue here again. Whether the Kava, the village authority, have the jurisdiction to try all this matter or not. That is
This
also
not the settlement.
Yes, Your Lordship.
In some situation,
this can be treated as settlement only.
Yes, Lord. In some situated matter,
If they have agreed, they have appeared and then accepted the compensation, this can only be treated as the settlement outside the court, which may not be treated as a settlement. For the purpose
but the
of criminal
difficulty
trial,
here is again,
criminal trial, admittedly, he has admitted his.
But the difficulty here again, they have prepared this application on merit, Your Lordship. They made them as a respondent, Your Lordship. It's not a joint petition again.
It will be trouble then.
Lordship.
Because if they have agreed, could have been joint petition.
Yes, Your Lordship.
Immediately after this. Immediately after acceptance of this compensation, could have filed joint petition.
Lordship, at that relevant point of time, the case was, the situation was different.
Now, since they are not the co-petitioner, it's not a joint petition, then they are a respondent. Since you are challenging on merit, then it will be decided on merit. And then this, if it goes on merit, then
this cannot be taken into consideration.
No. This goes against you rather.
Yes, absolutely.
On same situated matter, this coordinate bench has already passed the judgment in the case of Neelam Pope versus State of Arunachal, where the same things was carried out. The respondent and the victim and the complainant, they were settled by the CABA.
And then they were not the party to the petition.
Yes.
No,
They were
whether,
not a party, the victim were not a party.
and,
the
but they
petition.
contested, or they
But they were not contested. However,
filed affidavit before the High Court?
No any affidavit.
No, they did not appear.
Yes,
Similar case.
yes, Lord.
What it says?
Let's see whether it will be considered as a precedent or
What
not.
is the offense involved in that case? No, the extra EAC allowed
Yes, yes.
the compromise.
Here at the point of time, Your Lordship will kindly find in the para 11, the executive was discharging judicial function under the regulation of 1945. Judiciary was not separated at that time. Therefore, the judicial order passed by the executive authority had the same force as the order passed by the judicial authority in any part of the country. A judicial order passed in the country hold the field until it's set aside by the superior court. A judicial order may be correct or erroneous, but until and unless it is interfered by the superior court, it is a valid order. Here also the EAC, while functioning as a judicial magistrate first class, allow the compromise in a case of section 326 of the IPC. The offense is not compoundable according to the IPC, but somehow by mandate of different provision of regulation of 1945, the matter stood compromise. Therefore, again, subjecting the petitioner to file a fresh trial would amount to double jeopardy. Therefore, I have decided to agree with Mr. Patin so and so. Now here the issue here is, here in this case, it was not separated.
This case.
Fact is different.
Time and situation.
Yes, circumstances.
Time and circumstances is
Yes.
different. And then the reason for the agreement is also different.
Therefore, at this stage, Lordship may fix the matter for admission on next date. Because there is less possibilities to cause the service upon private respondent.
Even in a trial court, if the case proceeds, then this above decision will go against you.
That is the Lordship. However, why I am submitting this document before this honorable court is that to show that the settlement has been done between the and that part, the victim has been compensated.
This will be good enough.
And they have accepted the compensation amount also,
This will support you.
without any protest.
This will support you if they are also a joint petitioner. What? So what do we do with this? The steps, service upon the respondent.
Let us wait for the service for last for.
Because Your Lordship, if this court proceed further, then that court has to record the reason, and that should be with the authority of the court. But non-service of the notice cannot be the ground to proceed with this criminal petition. Your Lordship. That is one of the aspects. Yes. Otherwise, in all cases, then again the other matter has to be proceeded if the party doesn't appear.
Now the option would be that to publish in the paper.
Yes. Again, Your Lordship. For ends of justice, that can be done, no doubt, Your Lordship. However, it's not it is not there in the yes.
We'll
In the
wait for some more time. So let us see you point out that for how many times you have taken steps and jurisdiction, what options see that.
whether Your Lordship they have taken steps through jurisdictional PS or not, because it's showing Assam. Because from there, if any remark come, then basing on that the court can proceed, because the parties are from parties are from Assam, Manipur. From whether the jurisdictional PS from Assam steps has been taken or not.
Okay, in view of you take fresh step then. In view of the office note dated 12/11/2024, the Lorraine Council for the petitioner prays for allowing him to take press steps upon the responding number 5, 7, and 8 through the jurisdictional PS
Yes,
police station.
that is Demaji, this Demaji, Telam.
Their addresses are there.
Yes, Your Lordship,
Yes,
respect.
Okay, the prayer is there. The step be taken within a week from today.
But the problem would be there that whether the victim has rightly mentioned, given their address or not, that is the one.
Now,
aspect. During that point
let
of
the
time.
report comes that the addresses are not proper. Okay. That's for the finding of the pay
Yes, sir, absolutely.
within a week from.
Because
today.
we are taking
Start.
service only on the basis of the address given.
List
in
is
the
matter
charge
after,
sheet.
list is matter after 4 weeks.
Lordship, interim is there, interim.
Hmm?
Interim is there.
Interim is there. The interim or the past alias will continue to the next stage. Okay.
The
Obliged, Your Lordship.
Yes, now it's your time.
Yes.
Unserved notice, unserved, not served upon respondent number 4, number 1. No comment, otherwise. Only unserved notice returned. What is this case about? This is criminal petition. Oh, this is also quashing petition.
Yes.
Yes. What is this matter about? Telling me the order of.
For quashing the impugn order dated 12/7/2023.
Hmm?
For quashing the impugn order passed by the learned JMFC UPA or dated 12/7/2023. In complaint case number 25 of 2023.
What is the order about? What is this order? By this order, what the judicial magistrate has said. Where is the impugn order? Let us see once. Hmm?
Page number 193, Lord. Page number 193. 193. 193.
190.
3.
193. It's a complaint case.
Yes.
Okay. Is the one, respondent number 1 there. This will appear. So what do we do? You want to take press steps because it's returned? Probably the address you have to find out. What other respondent, whether the other respondent appeared earlier?
Not appeared, Lordship.
Hmm?
It did not appeared. The service is completed upon respondent number 2.
How many respondents are there?
2, Lordship.
Only 2?
Yes.
Okay, respondent number 2 appeared earlier.
No, no, Lordship.
So what do we do about respondent number 1? You want to take fresh steps?
Yes, we may be allowed to take places.
Earlier step was taken by way of register post. By the same process. In view of the office note dated 30/10/2024, the Lana Council for the petitioner, Mr.
Yes, Your Honor.
Praise for allowing him to take fresh steps upon the respondent number 2. The prayer is allowed. Step be taken within a week from today by a register post with AD, as well as by usual process. This is matter after 3 weeks.
Yes.
Okay. You find out the proper address of the respondent, probably since it has returned. So your address may not be correct one. Okay.
Lordship, interim is there, Lordship.
Interim is there.
Yes.
Stop. The interim order pass earlier shall continue till the next day. Okay.
Highly blessed.
Your Honor.
Yes.
I'm appearing on behalf of Tabatagum.
On behalf of
Tabatagum.
Tagum.
Yes, Your Honor.
What do you want?
This is his first appearance, Your Honor. He has been appointed as legal aid counsel. This is his first appearance. He has been appointed as legal aid counsel. Due to some urgencies, he got the court premises. Therefore, this may be listed as the 4 weeks.
Lordship, here, Lordship, it is 302, Lordship. Yeah, victim party need to be served notice.
302.
Lordship.
Not POCSO.
No,
Not
no,
under POCSO.
no, Lordship, this is 302. No, not necessarily, Lordship then.
Hmm?
Not necessarily. 302, Lordship. Actually, Lordship, here in this case, Lordship, this is 302, but it was wrongly mentioned, Lordship. Actually, it should be 3041, Lordship.
304.
Yeah, 1, Lordship.
1.
Lordship.
What is 1?
Lordship,
304 part 1.
yes, sir, part 1, Lordship. Part 1, Lordship, yes, sir.
So this Togum is privately engaged.
It's engaged by the this registry, Lordship.
Am I correct?
Yes, Lordship.
Registry means from the legal service or appointed by the.
From amicus curiae, Lordship. From registry, it is appointed, Lordship.
Okay. Never appeared till now.
No, Your Honor. This is the first appearance.
Trial court record also received. And then if the trial court record has received, then probably need to.
The paper book should be.
Paper book.
Lordship. Yes, Lordship.
Okay. Mr. Kambo appear on behalf of Tabatagum, legal. Oh, it's a legal aid counsel only. Legal aid counsel for the appellant. Staff. Miss Hage. Addition PP. is also present. Staff paper, trial court record has been received. Staff, let the paper will be prepared and furnished to the respective parties. Staff, list this matter after preparing the paperwork. Okay. After preparing the paperwork and furnishing the copy to the parties. Okay. 20? 20.
May I please, Lordship?
Yes.
Lordship, the service report of respondent number 80 is still awaited, Lordship. Rest are completed, Lordship.
Okay, you are Mr.
G. Thai, Lordship.
G. Thai.
Yes,
Islamic Council for the petitioner is present. The office note dated 25/9/2024 reflect that the service of notice upon the respondent number 8 is still awaited. In view of the above, this matter after
Lordship, there is an interim order.
3 weeks. The interim order passed earlier shall continue till the next day. Okay.
Sorry, Lordship.
Where is the interim order? By which order? Interim saying what?
22/02/2024.
Interim order shall be so considered upon the respondent entering appearance. Shall continue. There is no interim. What is the interim? Interim order saying what?
My lord.
Okay, someone.
Yes, yes. Kabasama.
Okay,
Yes.
the interim order passed earlier shall continue till the next day. Okay.
And my lord, earlier I forgot to mention that in item number 7, there is a interim order that maybe my lord continue.
Item?
Number 7.
7?
Yes, my lord. I forget to mention in.
No idea. We have already signed. 7, who recorded?
Yeah, I'm the petitioner, my lord.
Okay. That is why it's always better to wait for some time and then adjourn when the matter is called. It's always safer. Okay, in 7, kindly
Yes, ma'am.
include the interim order passed earlier shall continue till the next date. Okay.
Okay, much of that.
In 7,
Number 21.
Yes.
For the victim lawsuit.
This is conviction under
376 lawsuit.
376.
448.
IPC.
then
448.
376 4
Rape lawsuit. Rape.
no 4 and 440
448 lawsuit.
448.
okay.
House trespass.
So respondent number 2 has not yet appeared.
No
Not
lawsuit.
yet appeared.
No.
The service has been completed.
No, service, how it is completed, notice in respect to the economic action is record return back this is after closing of service. No one appeared.
No one appeared.
Then I think
Let's wait for some
for
time.
okay. Mr. This is item
21.
okay. You are Mr. Kepo.
K.
Posi, Islamic Council for the appellant. I've also heard Ms. Al-Hadi, additional committee for the state staff para. The service of notice upon the respondent number 2 return after closing service. Of notice. So however, no one appeared on behalf of the respondent number 2 Victim or informant?
The victim, Your Honor.
Victim, okay, start. That in view of the, it appears that the respondent number 2 is unable to appear, stroke, engage private counsel. Is unable to afford to appear, stroke, engage private counsel to appear on her behalf. So, in view of the above, the registrar, stroke, secretary, legal, High Court Legal Services Committee, so appoint one legal aid counsel from the panel of legal aid counsel for the High Court Legal Services Committee to appear on behalf of for the respondent number 2. List this matter.
Lordship, paper books should be needed, Lordship.
So that whether the record receipt.
Record should be there, Lordship.
Paper book. Yeah.
Not there. Record is there, Lordship. Paper book should be prepared.
Paper book need to be prepared.
Lordship, need to be prepared, Lordship.
To appear on behalf of the respondent number 2. Okay. Fair. The record also received that reflect that the trial court record has been received. So let the paper book be prepared and furnished to the parties. So, list this matter after the paper book is prepared and a copy is furnished to the parties. Okay.
Obliged.
Obliged.
May I bring Your Lordship? Yes. Your Lordship, I'm appearing for the respondent hearing. This matter may be disposed of today. Being the officer of the.
You are for respondent?
Yes, sir.
Okay. Why respondent is praying for this post?
Your Honor, being the officer
You're
of the.
for?
Petitioner.
Petitioner. What is this matter about?
This is, we are challenging here the inter-village cover decision, which is illegal one, as per the AFR. There is no existence of inter-village cover.
Okay.
There is a jurisdiction issue.
May I submit here?
Yes.
Your Lordship, the petitioner has been summoned by Parwana and re-Parwana, and accordingly Kaba was held, which is without jurisdiction. Actually, the parties belong to Isichiku village, particular village. They ought to have conduct Kaba at Isichiku village. However, they have conduct the village at Bango level, which doesn't have jurisdiction. Firstly, they have to conduct the village, conduct the Kaba at village level. Thereafter, they came for the appeal at Bango level. However, in the instant case, Your Lordship, they directly have prepared their Kaba at Bango level, which doesn't have jurisdiction. So I humbly pray that this matter may be disposed.
Okay. Bango level decided in whose favor?
In my favor.
Okay. Expert decision.
In my favor.
Okay.
But prima facie, it is without jurisdiction. But however, Your Lordship, I humbly pray that I may be given a liberty to approach the appropriate forum.
heard, Mr.
The council.
Planning counsel for the petitioner. So I have also heard. There is only sole respondent.
Yes,
Okay.
sir.
I've also heard Mr.
Ivan.
Idagom, planning counsel for the sole respondent. So, clarify. By filing this application under section 227 of the Constitution of India. Parwana was issued by Galu Welfare, so GB Welfare Society.
Yes.
And then again Re-Parwana also.
Yes.
Yes,
sir.
yes, sir.
Kava was also conducted.
Okay. 27 of Constitution, the petitioner has assailed the impugned Parwana within bracket Keba Summon bracket close dated 13/7/2024 and subsequently and Parwana is Parwana, they call it Parwana. Parwana dated 29/7/2024 issued by the head GB Toy
village.
Head GB no issued by where is the impugn order?
No, at
No,
page
impugn Parwana.
Parwana at page 21.
First Purwan is
First Parwana.
17 years. 17 is the first Purwana.
Okay. Issued by the head GB come GBWS. GBWS means GB
JBWS president.
it is issued by Shankar Prasad head GB come GBWS means Gambara Welfare Society.
Yes, Gambara.
Okay. Head GB H stroke GB come president GBWS president LR. What is this LRD?
Laparada.
Oh, LRD. Okay. GBWS president Leparada district, whereby the petitioner has been summoned last ED to appear before the said head GB come GBWS president Leparada district. Whether the date was fixed in the said Parwana?
Yes, that
for his appearance when?
27/20/24.
Okay, for his for his appearance. In connection with what complaint?
Yes,
Lodged by the respondent.
Yes,
in connection with the complaint lodged by the respondent for what?
For non-payment of the GST.
For
tax.
non-payment of GST
tax.
tax. Okay, stop. The petitioner has also assailed the impugned inter-village Keba decision. Is Keba or Kebang? Is
Keba.
Keba, yes, Keba decision dated 7/8/2024 passed by the inter-village authority led by means headed by only. This is where is the decision, impugned decision?
Page 25
2025.
and except 6.
Annexure page 25.
Headed by 25. Your type copy is?
Type copy is
29.
20.
Translated copy, page number
Okay.
20.
Headed by the, where is the head? Their seal signature.
Headed by Sri Henkin Basar.
Okay, headed by the head GB, come president. GBWS Basar Leparada. Okay. Where have you stated that this association doesn't have the jurisdiction?
In paragraph
Paragraph 14, Your Honor, it is mentioned that village authority and without
Just a
jurisdiction.
minute, okay, the para. The brief fact of the petitioner's case is that the, on 12/7/2024, the sole respondent had filed a complaint against the petitioner, how many numbers?
2.
Okay, petitioners before the President Rambura Association, Leparada District, Arunachal Pradesh, for non-payment of GST fees amounting to rupees 4,83,500 only for government tax after the payment of the first and final bill by using his firm MSLA Enterprise for the construction of Panchayat Bhavan Common Service Center at 11 capital A stroke 12 dash AC Chiku ESSI AC Chiku Gram Panchayat with sanction amount of rupees 25,000, sorry, 25 lakhs only. Stop. Para. That pursuant to the said complaint, the HGB, H/GB, President, GBWS Laparada District, Arunachal Pradesh, has issued the above impugned Parwana within brackets. It's a summon only, not notice, I think.
Summon.
It's summon, within brackets, summon, dated 13/7/2024. By fixing, whereby the state President GBWS Leparada District has fixed inter-village kebab on 20/07/2024 at Bangodere means Basar. It's a place of meeting.
Yes,
Bangodere.
community hall.
Okay, at Community Hall Basar.
Yes,
we can say community hall.
Community hall. There can be
Community hall
term as
Basar.
community hall.
With direction to bring both the parties with direction to bring their with the direction to bring their respective witness along with the evidence. By selecting GBs from many villages of Basar and Sago Circle.
Yes.
Okay. So, Subsequently, on non-appearance, the head GBWS Pasigat Leparada district has issued the impugned re-Parwana dated re-Parwana within bracket summon bracket dated 29/7/2024 by fixing intervillage kebab on 7/8/2024. With the same direction to bring the witness as well as the evidences from selecting GBs from many villages of Basar Circle and Sago Circle staff. Sarah. On receipt of the said Parwan, the said impugned Parwan, the petitioner has submitted representation before. You have addressed where is this?
In excerpt 5,
Page 23.
To the President President of GBWS Leparada district with a request. You have not pointed out that they doesn't have the jurisdiction in that side of application.
Yes, it is mentioned. Actually, they have written that Isichiku village have a jurisdiction to deal with any dispute arise between parties.
So where
it is there in representation dated 5/8/2024, and excerpt 5, page number 23.
Where it is?
Fourth page.
So fifth line. Fifth line. Starting of fifth line.
Okay. Informing the said president that the Chiku village authority has village authority has the jurisdiction to try the said case. And it is not a case of the inter-village, it is not a case to be decided by the inter-village customary court. Yes. Thereby indicating that the president of GBWS Leparada district doesn't have the jurisdiction to try the conduct Keba. Conduct Keba at what level? Circle level?
Yes, sir. Circle level.
At circle level. Stop.
Bango level, sir. Bango.
At Bango level. Yes. Bango is a circle only? No.
Not exactly circle.
Bango level, which is the appellate authority.
Actually, Your Honor, when
is it the appellate authority?
not exactly appellate authority. When parties are belonging to different villages,
Okay.
then only Bango level Kaba can be conducted.
Instead of Bango level customary court, which is okay. Chico village, which has an jurisdiction to try the matter instead of inter-village, I have said, no? Okay. Fair. It is submitted that the jurisdiction you are submitting on what basis? They doesn't have a jurisdiction under what?
Didn't come with the act as per the Arunachal Pradesh Civil Code Act.
Section?
Section, exactly don't remember.
Okay, it is submitted that the head GB cum president GBWS Leparada has no authority. That is para, to issue the impugned Kebas summon dated 13/7/2024, 29/7/2024. Nor has he the authority to pass the impugned inter-village Keba order dated 7/8/2024. So before that, I think we have missed out one paragraph, no? Because thereafter also, only after that, they have proceeded to settle the matter, isn't it? After issuance of Parvana and then you submitted representation. Thereafter, only they have settled.
Yes.
However, after that, the earlier paragraph, however, where is the settlement?
Kaba decision.
Okay, decision, okay. However, the however, the president of GBWS Leparada district, Arunachal Pradesh, proceeded and proceeded to conduct inter-village Keba and pass the impugned inter-village Keba decision dated 7/8/2024. Under the chairmanship of Sri Henkar Basar, HGB, Soy Village, come of the president of GBWS Leparada district, Arunachal Pradesh, whereby the petitioner have been directed to pay 16% amounting to rupees 3,86,723.84 only. What is this? Another figure out of rupees 24,000, 24 lakhs, the 24 lakhs, 7,024 only. Okay, stop now. Para, being agreed. Thereafter also you have submitted something?
No.
Application?
No.
Okay, being agreed, being highly agreed, comma, the petitioner is before this court by filing this CRP. Start, I see by filing this civil division petition. Amongst other on the ground that the head GB president GBWS Leparada district has no jurisdiction to issue the impugned Keba summon earlier, no? Dated 13/7/2024, 29/7/2024, and the said head GB come President GBWS Leparada also doesn't have the authority to pass, have the power and authority to pass the inter-village KEBA order dated 7/8/2024. So, 2024, semicolon, and by passing the same summon and passing the same summons as dated 13/7/2024, 29/7/2024, and the order, impugn order dated 7/8/2024, the head GB President GBWS has exercised the jurisdiction not vested in it by law. Therefore, the Land Council for petition. Therefore, the Land Council for petition contended that the summons, the impugned summons, and the order the impugned summons, right, dated 13/7/2024, 29/7/2024, and the order dated 7/8/2024, which was issued without any jurisdiction. Requires to be set aside and passed. Stop, Mr. You are Mr. Okay, Land Council appearing on behalf of the sole respondent. Fairly submits that, in fact, as per the Arunachal Pradesh Civil Code Act 2021, amended from time to time, amended 2023 or 22? 23. The president, the head GB come president, GBWS Leparada district has no jurisdiction. Jurisdiction to issue the impugned KEBA summon dated 13/7/2024, 29/7/2024, and he has no authority and jurisdiction, as well as jurisdiction to pass the impugned intervening KEBA order dated 7/8/2024 in the instant case. Stop. The Land Council for the respondent, while conceding the submission made by the Land Council for the petitioner, also submits that by issuing the impugned summons, and also bypassing the impugned order dated 7/8/2024 from the head GB come GBWS, head GB come the president, GBWS Leparada district has exceeded, has exercised a jurisdiction not vested in it by law. Therefore, the Learned Council to the respondent submits that the impugned summons and the order, the above impugned orders and summons issued by the head GB President GBWS Leparada district needs to be set aside and passed. However, the Learned Council petition. What is your submission? You said you want to approach the
Appropriate forum, that is EC Chiku Bill.
okay. Praise that he may be allowed to approach the appropriate forum is for redressal of the grievance of the petition of the respondent. Yes, respondent was the informant in that, complainant in that case. Is it okay? Respondent. Sorry. Okay. Fair. In view of the above, sorry, heard both the Learned Council for the parties. I've also perused the records available on, the documents available on records. Also, has gone through the act. So the relevant act, the relevant provision of the act stuff. Upon hearing the parties and on perusal of the records and also and perusal the records, it appears that the complaints lodged by the respondent. The respondent had lodged a complaint against the petitioners before the head GB President GBWS Leparada district. And on receipt of such complaint, the head GB President GBS Leparada has issued issued summons dated 13/7/2024, 29/9/7/2024 without any jurisdiction. Not only that, the said head GB President GBWS Leparada district has also went on to pass the impugned order dated 7/8/2024. No, 2024 without any jurisdiction. From the record, it appears that from the record and the submission of the party, it appears that the jurisdiction to decide the complaint lodged by the respondent lies before the EC Chiku village. EC Chiku village, and before the customary court of the EC Chiku village. Yes. And not before the, what was that? Bango Keba. What was that Keba? Not before that, not before the inter-village territorial customary court. That is customary court, or before the head GB president, GBWS Leparada district. Stop. From the above, it prima facie, it appears that by issuing the impugned summon dated 13/7/2024, 29/7/2024, and the impugned order dated 7/8/2024, and by passing the impugned order dated 7/8/2024, the head HGB GBWS has exercised a jurisdiction not vested in it by law. Stop. In view of the above, and in view of the above, I am of the opinion that okay. In view of the above, and for the reason stated, in view of the above, and for the reason stated above, the impugned summon dated 13/7/2024, 29/7/2024, and the subsequent order passed, it's order dated 7/8/2024, passed by the head GBWS Leparada, needs to be set aside and was. Accordingly, the same is set aside and was. Stop. With the above, this CRP civil revision petition stands allowed and disposed of. Stop.
I would like to make one simple prayer, you know? Since it is a monetary dispute between the parties.
Okay.
So a respondent can approach the civil court
It is made
also.
clear that the respondent is at liberty to approach the appropriate forum for redressal of his advances.
Yes,
Okay.
sir. Yes, sir.
Okay. Yes.
Right, Your Lordship, here TCR was called for and it has been received, and there is an interim order was there, Your Lordship. It's saying the process.
Present.
Yes, petitioner not present. So for ends of justice, let this matter after 3 weeks, Your Lordship. Let this matter be set after 3 weeks since the petitioner is not present today. And it's a joint petition, Your Lordship.
For joint petition.
Yes, Your Lordship.
Record received or not? No.
Yes, TCR received, Your Lordship. It's
Okay.
showing directly.
Okay, no one appears on behalf of the petitioner on call. Start. However, Mr. Lanek, additional public prosecutor for the state respondent is present and produced a trial for the court. This is to be sent back or what?
No, Your Lordship. Trial court,
It's
since
a
it is
scan copy.
Yeah, scan copy, and it is through registry only.
Yeah. However, Mr. Lanek, additional PP, the public prosecutor for the state, is present and submits that the trial court record has been received. In view of the above, in absence of the Rani counsel for the petition, the matter could not be taken up. Accordingly, the matter stands on. At least this matter after 2 weeks. 2 weeks.
Yes. Your Lordship, this is the matter, Your Lordship, which I've mentioned yesterday, CAB matter. Your Lordship, I have been informed by, yes.
Here, it was already dictated.
Yes, Your Lordship. Now, Your Lordship, what my humble, Your Lordship, suggestion would be, Your Lordship, let registry be directed to obtain status report of this case from the trial court. Status report from the trial court, Your Lordship. Although I have been telephonically informed by the concerned, Your Lordship, this is register from the by seeing the record. That they have informed me that the matter cognizance had not been taken and charge sheet was dropped because the 188 was there.
This is verbally only.
Yes, Your Lordship. So what my humble submission before Your Lordship.
Now, whatever may be, think, in any case it will go.
Yes, Your
Case
Lordship.
goes.
Yes, yes. In any case, it will go.
Then, whatever may be, let it go.
Yes, Your Lordship.
Since it's CAB.
Yes, then Your Lordship, in that case, Your Lordship, this regarding the instruction may not be recorded. Otherwise, Your Lordship.
Only you just give the GR.
GR number. Yes, Your Lordship. I will
So
give.
that will go.
Yes, I will give the
I
GR number.
dictated.
Yes, and regarding that part, I will give silent, Your Lordship. That
Correct.
part, if it is come into the record that matter has already been closed before the learned trial court, then
Because it was duty of the petitioner only.
yes, Your Lordship,
It was
absolutely.
duty of the petitioner.
Yes.
Petitioner, without knowing what is their status, what is
Yes.
their case,
Yes,
they have filed it.
yes, Your Lordship.
So
Then
let
we'll,
it go, let
we'll,
it go.
yeah, we'll keep that part silent that regarding the closure of that matter, since it has order has matter as Your Lordship has already dictated the order. I will provide the GR number.
GR number. You
Yes,
just
Your
provide
Lordship.
the GR
Yes, yes.
Where is it? Dictated on platform, it's there, printed. Okay.
Because
So GR case number would be?
GR, yes, I will provide the GR case. Because Your Lordship, nobody has informed this court regarding the status, dependency, whether it was pending.
It was the duty of the petitioner only.
Yes, Your Lordship. GR number is 331 of 2020. Yes.
GR number.
331 of 2020.
Okay.
Yes.
Arising out of the same previous case. Okay,
Yes,
that's
yes, Your
good.
Lordship.
That will.
Yes, Your Lordship, because the other part is not in it. Yes.
AB
Yes.
can announce tomorrow also.
Yes, yes, Your Lordship. You can announce tomorrow itself. Your Lordship. No issue.
Then get it listed tomorrow. Yeah.
Yes.
So today it's been listed.
Yes, Your Lordship.
Okay, fix it, no?
Because Your Lordship, it is my duty not on record, but
Right.
I have to
right.
apprise this court. Your
Okay.
Lordship.
Then 28, is paid for by the council to the parties, list is matter.
Tomorrow.
No. Both the land council for the parties are present, staff, huh? This is matter tomorrow, huh?
Yes.
So
Judgment.
judgment. Yes. Okay.
Yes. Deeply obliged. Sir.
Understood.
May I please, Your Lordship?
Yes, this was the lordship morning.
Yes, Your Lordship. I have instruction to withdraw this petition. Your Lordship.
Okay, yes, you are Mr.
E. Major, Your Lordship.
Land council for the
Petitioner.
petitioner has an instruction to withdraw this civil division petition. The prayer is allowed. The civil division petition stands disposal is on withdrawal, okay? Okay.
I leave, Your Lordship.